I'll read the rules.
Handouts and displays should be approved by the city clerk prior to the meeting. Prior to speaking, each speaker will complete a speaker card and present it to the clerk before the beginning of the public comment portion of the meeting. The public comments portion of the meeting will last 30 minutes, and speaker cards will be accepted on a first-come, first-served basis. Each speaker will be allotted 3 minutes to speak and will identify themselves by name, address, and if applicable, their organization before beginning their presentation. In order to respect the time of each speaker and the right of all citizens who wish to speak, neither the mayor nor any city council member nor any City of Brookhaven staff shall cut a speaker's time by engaging in dialogue, answering questions, or responding to individual issues, concerns, or questions raised by the speaker. Only after all speakers have been heard and the public comments portion of the meeting has been closed will the mayor and council be able to address any concerns raised by the speakers. Any member of the public who does not get an opportunity to speak will be allowed to speak first at a subsequent meeting, and the clerk will hold their speaker card until the date they choose to return.
Thank you. Is there an invocation? Anybody want to volunteer to? Doug, would you mind doing the invocation? Thank you.
Let us pray. Dear God in heaven, we come to you tonight thankful of the opportunity to gather in a free society and together to hear and debate those issues that are important to our community. The thing that we ask is that we always understand that your love and guidance is what we seek, and your wisdom and obedience is what we strive for. And so we ask as we deliberate these issues tonight that you guide and protect us all, and that the decisions that are made here are in the best interest of the protection of the creation of your ordered society. We ask in thy name. Amen.
Amen. Thank you. If you call the roll, Madam Clerk.
Mayor J. Mance Davis.
Here.
Councilmember Joe Gebbia, District 4.
Present.
Councilmember Bates Madison, District 3.
Here.
And Councilmember Rebecca Chase Williams, District 1.
Present.
All right,
All
folks.
present, have a quorum.
Thank you. Please stand for the pledge. Pledge allegiance to the flag
Of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Opening remarks. Just remind everybody to come to the food truck event tomorrow night. The weather's changed. It's so nice. Nathan Shepard, a very talented musician, will be playing, so you wouldn't want to miss him. Also, October 19th, you'll see the little sign back there, Live in the Park. That's going to be at Blackburn Park. That's going to be it's our first little music festival that we've starting for the city, just to be a sort of a demonstration project to let folks know that we want to bring festivals and music festivals and things of that nature to Brookhaven. And we had the Soccer Fest, which was wildly successful. And this is meant to be a smaller festival at Blackburn Park, which will rotate it to other parks. But we just want people to come out and enjoy. There'll be a kids entertainer there, Mr. Greg. He's a Brookhaven resident. He's on PBS for being a very well talented kids musician and entertainer. And then we have Housebroken, which is also a Brookhaven band. I'll be playing some songs with Housebroken during their set. And also the last band is Journey Resurrection, which is a Journey cover band, and they sound better than the present Journey you see right now, because you ought to look them up on YouTube, but they're really talented, and I'm excited about it.
Great.
Any announcements from you? All right, anybody else? All right. Sorry we started late. We had a sort of a lengthy executive session. Are there any agenda announcements? Okay. Public comment. First public comment?
None.
None for the first public comment. Consent agenda.
Yes, Mayor and Council, there are 3 items on the agenda for consent, and they are the meetings for different meetings, council meetings and work session.
All right. Is there a motion?
I'll move that we approve the consent agenda.
Second.
Any discussion? All in favor of approval of the consent agenda, signify so by saying aye.
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 All opposed? Was that 3 ayes?
It was an aye.
Okay. The consent agenda is approved. Announcements,
No announcements.
reports, and presentations?
Yes, the police chief has some commendations that he wishes to make.
Mr. Mayor, members of council, we have two different incidents today that we'd like to present commendations for. So first, if I could have Officer Maria Gresham, Corporal Lonnie Napier, and Detective Camilla Patterson come on up. Just to recap on this first incident, on September 12th, Officer Maria Gresham responded to Northside Hospital to report of an accidental gunshot wound to somebody, to a male's hand that was being treated at the hospital. Officer Gresham started talking to him, and she went a step further. Most officers probably would have just taken an accidental gunshot report that supposedly took place on North Cliff Valley in the city of Brookhaven. She extended the investigation, started asking questions, really got nosy into it, and did a great job. She ended up calling up Corporal Napier and Detective Patterson. They assisted in the investigation, but what happened was she called a girlfriend back who supposedly accidentally shot her boyfriend in Brookhaven and was able to recover a gun out of the car and determined that it was actually a setup that took place in Sandy Springs where the two of them went to buy a PlayStation at an apartment complex. They ended up getting in a tussle, actually tried ripping off the owner of the PlayStation. The girl had a gun while they were seated in a car. She fired a shot. It went through her boyfriend's hand and ended up killing the person in the apartment complex parking lot. They found him through their efforts. There was an off-duty, I think, Sandy Springs officer working at the hospital. He said they had a homicide in Sandy Springs. They were able to actually turn over both suspects to Sandy Springs. So for that, we'd like to applaud them for a job well done.
Wow. So will they be getting a commendation from Sandy Springs? I would think. They caught a murderer because of that. Is that correct?
Two
That's-
murderers.
Wow.
I think both of them were actually charged. It was
Felony
in the
murder?
news today. Yes.
Wow. Get a picture.
So why don't you stay up here for a minute? The second one, if I could have Officer David Fikes come on up. And this one, I'll start out on September 14th, Officer David Fikes was in the area of the QT gas station on Buford Highway. He noticed a subject, I think was coming out of the station, and he had something that appeared heavy in his pocket, and he just didn't look right. He was talking on his cell phone, so he approached him because we have a lot of issues in that area, and he ended up finding some drugs on him. I think he had marijuana on him, and he started searching him, incident to that arrest, and asked him if he had anything while he was searching. He found a loaded .25 caliber handgun. The person ended up being 14 years old only with an extensive record. So he was charged with that, and through Officer Fikes' interview techniques or whatever, he was able to clear up, I think it was 5 burglaries that took place over the past 2 months in the city.
Wow.
So another job well done by Officer Fikes. So.
Shoulder.
Squeezing in.
There you go. I knew there was one more.
Sounds like a news story, catching a felony murder just by asking how your hand got shot.
That was a big, it's been a big story on the news. It's a horrible murder where a couple went to supposedly go buy this PlayStation that they were going to buy on Craigslist, and then ended up shooting the guy. It was terrible.
Shooting the owner of the
So-
PlayStation.
Yeah,
God,
which makes you a little cautious about Craigslist.
God.
But
Over a PlayStation.
good job clearing it up, because it was bad.
Yes, thank you. All right.
Next item on the agenda are the public hearing matters. We do have 5 cases. First case, it's a public hearing, RZ 13-11, SLUP 13-01, and SLUP-1302, John Hancock Life Insurance Company, rezoning request from OI Conditional Office Institution to OI at 4170 Ashford Dunwoody Road, mixed-use development consisting of 500 multifamily units, 563,578 square feet, 250,000 square feet of office space and 3 parking decks, special land use permits to exceed the height of all building structures over 5 stories and 70 feet, and for development of high-rise apartments in the OI zoning district. Mayor and council, we did receive a letter requesting that this item be deferred until the December 16th city council hearing. The attorney for the applicant is present in the event that you have any questions, and we can move to have the public hearing open, or you can take the deferral.
I don't have any questions. Did you have any comments?
Thank you, Mr. Mayor. I'm Doug Diller with Wiser Noack, Curry and Wilco. As you might recall, this matter was deferred because you were in the process of
We're opening the public hearing now, correct?
Yes.
Yes, all right, go ahead.
Thank you for the record.
Sorry.
I'm Doug Dillard with Wiser Noack, Curry and Wilco. As you might recall, this matter was deferred primarily because you were going through the review and readoption of a comprehensive plan. You've not done that yet. Also, we're proposing some retail as a part of the mixed-use development on this property, and it would be available for others that are not just tenants in the office building. It would be available for the community. And the ordinance as currently written that you inherited from DeKalb County restricts that retail to tenants of the office buildings that are located on site. So we're putting some residential on top of retail, and so we need to amend that ordinance. And we've met with Commissioner Williams and Councilperson Williams and Marie and Susan about trying to provide that new ordinance, and also you've not adopted your comp plan. So we thought that deferring this matter to December would give us time to do all that. So we would ask that it be deferred in accordance with our letter request.
Thank you. Is there any comment? Public comment? Anybody signed up?
Against.
Yeah, that's fine, yeah.
Tim Halloran.
You'll set that to 10 minutes.
Good evening, Council. Tim Halloran, 2 second graders at Montgomery Elementary School, speaking here tonight as a parent, also representing a number. We understood there was going to be a deferral today, so I'm here to represent a number of concerned families of the 753 students at Montgomery Elementary School. One of the other things that you all asked the developer and Mr. Diller to do was reach out to the school to talk through this since April. May, June, July, August, September. We have not heard anything from them. No one from any of our, so we're ready to talk, we're ready to listen, but we're ready for them to reach out to us as you directed. They talk about John Hancock being a good corporate citizen, and I think being a good corporate citizen would be to adhere to the direction of the mayor and the council and reach out to the school. We are more than willing to try to come up with a solution to work with them, but again, have not heard anything from them since that meeting. So, thank you.
Rebecca, do you recall, I think what we asked is reaching out to the school and the neighborhood, not just the school, correct?
I don't know that I could remember exactly what we directed. I think the point was that any development that is still in negotiations like this, you presume they'll continue to meet with interested parties. I mean, I've personally met with the school superintendent to talk about the issues of traffic and issues around the school that pertain to the Ashford Green development, but it's really up to the developer to reach out. I believe there had been some community engagement before the last meeting, but I'll let Mr. Dillard respond later on that, or whenever it's appropriate for him to come up.
All right.
Erica Kaplan?
Ms. Kaplan?
Good evening. My name is Erica Kaplan, and this is my first time speaking at a public forum.
Welcome and congratulations.
Thank you. I actually live at Villa Sonoma condominiums, and I'm not sure if you all know where that property is by Villa Christina, and there's some high-rise buildings there. I'm very, very, very concerned about this high-rise being built. There are 321 units over there that have depreciated significantly over the last several years, obviously due to the economy. I don't know if y'all are aware, but there was a pretty significant fire there on March 20th that was in the news. We were displaced for a period of time. And apparently the fire department, and I'd be happy to share the report with you, was delayed in getting to our unit or our buildings because of the traffic on Ashford Dunwoody Road coming from 285 towards Johnson's Ferry Road. So I'm concerned on so many levels as far as my property value goes. I think I can speak for a lot of the residents that are there, but it's really disturbing how congested that area is. And I just wanted to bring that to your attention, that I'm not in favor of this condo high-rise. Thank you.
Thank you. Next.
Michael Rock?
Mr. Rock? I don't see him. There he is, hiding.
Thank you for giving me the chance to speak with you guys. Nice to see you again. As was referenced before in April when we spoke, we left that meeting with the impression that we would be met with some kind of communication from the gentleman and the developer. It's our intention to be cooperative and respond to that communication. I think that from the developer's point of view, I think we all recognize that development is something that's going to happen. I think the kind of development is what is in question here, that it's in the best interest of the taxpayers and the citizens who live in that area, not just for what the developer wishes to proceed with, should be taken into great consideration. And I don't think that, to Tim's point earlier, we have been met with much communication with respect to that and the directive that you provided last time. So we are willing, open, and able. We just look for a cooperative party to reach out to us and talk over these things with us, and we're happy to try and come to some great resolution. I think it works better when all parties can say aye rather than nay. I think the developer would certainly agree with that, so we look forward to that opportunity. Thank you.
Thank you. Next.
No.
How much time is left for the against?
6 minutes.
Okay. And how much time left for the presenter?
Yes, 9
9.
minutes.
Thank you, Mayor. We're always willing to work with the community. We've had meetings at Montgomery Elementary School, which was very well attended. I think y'all might have been at one of those meetings. And I regret to say that we've not been able to reach an agreement at this point. We're always willing to meet with the community, and we will reach out to them one more time to see if there's some way that we can reach an accord. We do have an agreement with certain residents of the Oak Forest neighborhood, which is directly across Ashford Dunwoody from the subject, and I think at the last hearing they testified in favor of this. We've done a traffic study. We've tried to reach out to the community, and we're more than willing to meet reasonable demands, but at the same time, we're not going to probably agree to those demands that we think are unreasonable. John Hancock is a good corporate citizen. They have been a part of this community for a long time. They want to continue to do so, and we're more than willing to meet with those residents that are affected. I think the deferral will allow us that time. We will reach out one more time to Tim and his group, and we will also meet with the condo owners that are affected. I don't know that we have met with them, so we appreciate your indulgence, and we also look forward to a recommendation from the comp plan adoption that will confirm that this is in fact consistent use for this property, the effect on infrastructure, and the 18, I think there's 18 conditions that staff has suggested, which we're agreeable to, relative to transportation and road improvements and the preservation of landscaping in the area, are things that we're willing to do that have been recommended by staff. So hopefully when we come back to you in December, we will have an agreement, but we will reach out one more time to Tim and his group and to the Christina Valita folks and see if we can work something out. So we thank you for your indulgence. Thank you.
Could you reach out 2 more times if it's necessary? All right.
Mayor and Council, if I may, I know the date, December 16th, has been written and tossed out a couple of times. The staff will certainly react to whatever the plan is that we receive, and it may necessitate re-advertising, so I just want to make sure that the public is aware of that in the event that we're not able to meet the December 16th request before you tonight.
Is the ordinance, will it be ready, been adopted by then? The ordinance revisions?
That would be the plan, and we're going to have something back to the council at the next meeting.
Okay.
On the work session for discussion.
All right.
In addition to that, also if we could request that the applicant submit whatever it is in terms of a revised site plan by a date certain of November 3rd. It'll give staff enough time and the appropriate amount of time to review the site plan.
Okay.
Can I ask the applicant a question? Do you anticipate revising your site plan into more of a truly mixed use? You just mentioned that you
I can't answer that until, at this point, no. I think at this point, we're showing a fairly minimal amount of retail as it relates to the residential. But we're obviously willing to react to whatever we think would be acceptable to the city and also doable as far as the application is concerned. They're pretty firm. They don't want to reduce the density. Now, whether we can increase the amount of retail and other uses that would increase the relationship of the residential to retail, we
You
certainly.
mean bring residential down and bring retail up?
No, they've been pretty firm that we're proposing 250 rental units and 250 owned units. And the client's been pretty steady that the rental units will probably be built first, and because the condos are relatively difficult to finance in this market. But we're certainly willing to talk, I
Well,
think.
you mentioned that you were anticipating some retail below the residential, and that's not quite what I understood then from your latest
Well,
site
I might have
plan.
misspoke, but.
Because right now, it's all in the office, right?
Yeah, it's all office right now. And
That's
so
only what's allowed.
That's what's allowed, and it's 18-story building, and so we're reducing that. And we're
To 11.
reducing that to 10, I think it's 10, maybe 10 or 11. All right, it might be 11.
10.
And then there's 10 to 20,000 square feet of retail in the proposal.
I'm just curious as what you would think would be on the table to negotiate if the owner is firm that the 250 units is staying as is.
I just don't have any, I don't know. I don't have any authority to say we'll reduce the residential.
No, I'm not
And
asking you to.
last night, we had another public meeting last night with the McCurdy County folks and some of the Murphy County folks and some of the Forest people. And the client was pretty firm that the 500 units is a firm number for them.
Is that the
now,
main issue?
I think so. I don't know that the retail's that big of an issue. The traffic is obviously an issue, and if you look at the staff's recommendations, we're making significant roadway improvements on and off-site for Ashford Dunwoody Road. And we're also prepared to preserve the PCID conditions on landscaping for the Perimeter Summit area that we are a part of. So we're not going to destroy any of that landscaping. We're going to add a lane on Ashford Dunwoody. We're going to do a free right. We're going to improve the intersection at Oak Forest and Perimeter Center Parkway, and we're going to extend it down as far as our property goes for the improvements.
Is it correct that, my understanding from the developer was that if you go forward with the 500 units, you would do it in phases? You would do one building at a time?
That's correct.
Who knows how much time would be between each one, right?
That's
Probably
correct.
as the market bears. Okay, I'm asking you to put on your textbook writing hat now, too. Is there such a way that you could split the zoning on that so that you come back to us with just the phase one? And then we have a chance, after it's built and we see the impact of the 250 units, that then we could rule on the second half or somehow give you a conditional zoning based on coming back with the site plan? Or I think what we'd want to see, the fear that everybody has is that the 500 units is just too many. Seems to me it might be reasonable. What I don't know is if it's legal, if there's a legal way to do this, for you to go ahead and build your 250 units. Let us see what impact that has on the roads and the schools, and then come back and make an assessment about the second 250.
We've not addressed that issue. I would think that if we did it that way, that we would want to preserve the office density for the difference. So let's say we're giving up 500,000 square feet of office for these units. If we can't build those units, we would have the option of being able to build the office. Now, I don't have authority to suggest that, but I think where you're looking at giving up office density in exchange for residential density, and you're really looking from a traffic standpoint, you're looking at significant difference in impact on Ashford Dunwoody Road between the two.
More traffic with the office.
Yeah, more traffic with the office, that if we're not going to give up that square footage
Right.
if we can't build a residential unit. So whether that's a compromise that John Hancock would be willing to consider, the site plan certainly doesn't address that.
No, in fact, what I don't know is if I was looking at that site plan saying, well, where would you put an office building if you were to build, say, 2 office buildings and 1 apartment complex? I don't know if you would just switch them where they are.
Well, you know, the thing about what we're doing is that we're giving up the tallest building. We're going to keep a 10-story building,
Right.
but we're giving up 8 stories of office. So I would think that we would then be looking at another 8 or 10-story office building if we can't build the condos.
Right.
And I don't have the answer to that. We've really not had that presented to us, but I know they're willing to consider.
Well, would you
looking
give
at
it some thought and talk to our staff and just see if there isn't, it just seems to me that might be a way to solve this conundrum and get you what you want and get the community what it needs to have. And I would understand you wanting to preserve your right to build the office building, so I would factor that in.
Well, you know.
And if the plan wasn't to build it all at once anyway.
I think we need to look at, and I've been involved in litigating over this area, as you well know,
We don't
for a
want to
long
litigate
time.
about this. We want to
And I
come
don't
to a
either.
good resolution
Look,
on this.
Look, I took this piece of property to the Supreme Court twice, so I'm not
And
looking to do it again.
you know it well, I know.
I don't want to do it again. No, I don't want to do it again. But the other side of it is I think we need to look at not just this piece of property, but as it relates to the whole area
Right.
from the hospital here, and whether or not, in light of the non-residential that's already approved in Perimeter Summit,
Right.
how this residential fits not just on this site, but how it mixes with the entire
of the site,
community
I know.
that's on the south side of I-285.
All right.
So,
Well, thank you,
so
Dal.
the answer is yes, we're willing to look at it.
All right.
You know, I don't have authority to say yea or no.
All right.
I'm not
tonight.
asking for an answer
Yeah,
now. I'm
no,
just
but we'll
asking
look
if you'll,
at it.
if you'll
Sure.
look at it, just
Yeah.
a
All right,
sort of
sure.
a thought I had the other day.
All right, I want to ask the residents who are here a couple questions too, if they want to come up. And you finish, you have a little bit of time left?
I was going to mention to Doug, I think, Tim, are you still head of the, where's Tim? Are you still head of the foundation?
Well, I'm technically past president, but I'm
Hold
still
on,
on the
just hold, let me make
foundation.
sure.
Just want to
hold-
make sure
I
that
got
Doug
you.
has the right contacts.
Gotcha, I know, I just want to make sure that the times are fair. That's all I was doing.
Sorry.
So if we start asking the other guy.
Sorry.
Yeah, so does he have any time left, Mr. Dillard? All right, so and they have 6 minutes? All right,
I'm done.
okay, all right. Would y'all, was I correct in pointing out that the number of units is the main sticking point for
That's a
the,
major sticking
for
point.
the
That's a-
main one?
Yeah, that's the
Okay.
main one, yeah.
What is the number two?
What is
What's the number two sticking point?
Traffic, I mean, just the ability of
Caused by the density of the-
Caused by the density of the apartments and the
Okay.
condos, and the ability of the school to take on additional students would be another one.
I would simply add to that also that the impact of property values by having apartment complexes across from single-family homes would be of great concern, as well as the chance for another issue such as the one at Villa Sonoma with another crash in the market would also drag down property values.
All right. All right. So it seems that the issue is the number of multifamily units is the main sticking point. And that's what Mr. Dillard's client said he's not, or he doesn't know if he's going to move on.
If I can just simply add also, it's not just the number, but the type. So in your negotiation or discussion just a minute ago about the 250 number, we would be very open to discussing the complex, or the makeup of that 250, which could allay some fears as far as property values.
What
are
is your
concerned.
understanding of it, is what the mix of it is now?
I understand.
It's changed a lot. I mean, it kind of goes.
As it stands right now, the way that we understand it is 250 apartments with 250 condos. I think the apartments are the bigger concern than the condos
Right,
are. So
right.
if that negotiation you just had discussed or brought up, the exchange of the increase in the tower or the commercial property were to go up, we would be in favor of talking about that and discussing it in favor of a reduced number of 250 apartments.
Right.
See, because the bigger issue for us is the school crowdedness and the traffic at 7:30 in the morning, when all these people that's when Montgomery starts. That's when all these people are going to be going out onto the road.
Right.
Going to their respective workplaces.
Right.
So, yeah, go ahead.
Well, just to state the facts, in the fire department report, they were dispatched at approximately 4:25 PM on a Thursday. They could not get over 285. It was just gridlock, and that unfortunately, we still have approximately 43 units that are still gutted, not necessarily from the fire caused in the roof, but there was so much water damage. And like I said, I'd be happy to send you the report.
All right. Well, thank you all very much.
Thank you.
Thank you.
Sorry to keep you, Tim.
Make sure that Doug's got the right contact.
He should have.
Are you, Michael, are you with the homeowners or with the school group?
I'm with the board as well for the school group.
All right, is there, Nancy Creek Heights, have they been involved in this at all?
I think he's talked to a few neighborhoods,
Okay,
yeah.
all right.
But I'm
And
not
Oak
sure
Forest is, which is next to Nancy Creek Heights, and then across the street, Dunwoody Forest?
We had a meeting with them last night.
Okay, all right.
So,
So y'all gonna have another meeting?
we are more than willing to, we have a team that would, to talk to them. So we had to, literally, we had to talk to Brookhaven Post, we had to call City Man, we were like, what's going, we had JD Clockdale call people, we like, what's going on? They're on the calendar on September 23rd, and we haven't heard word
Okay.
one. So,
Well, he's just agreed to,
willing and able to talk.
right?
You want to set up a date now? We'd be happy to do it.
That's
I agree with my
fine.
son from swim
We-
practice.
We've had the meetings. Client had a meeting with them before the last hearing. They came in and opposed it, and it sort of shut down all
Right.
negotiations. So we thought we had some dialogue, and result of opposition to the last hearing, that sort of got terminated. So we're always willing to talk.
Yeah, exactly.
We were talking, and things were being made.
Gotcha.
Back and
All right, we're not gonna get into the specifics, but y'all need to meet again. Thank you all very much. All right, any more comments? All right. Next.
Yes. Next item is the RZ 14-12 Amendment 2 and the readoption of Chapter 27, the zoning ordinance of the Code of the
Wait a
City.
minute, they got to vote to defer.
Oh, excuse me.
something.
Yes.
We have three items. I don't know if they want to do individual votes. or-
Yeah,
All together.
right.
You need to close the public hearing.
Yeah, we'll close the public
Thank
hearing on
you.
on item 1.
And you have 3 ordinances under item 1, so
Okay.
I think one motion
Sure.
could take care of
Okay,
all of
one
them.
motion under,
You
hey,
have a date certain. to defer
we need a
this.
motion.
Do we have a date? Do you have a date certain to defer these two?
They're asking for December the 16th, but with the caveat from staff that if there is substantial change to the site plan, then it would have to be referred back to the Planning Commission.
Okay.
So we want to be sure that we're covering that, but we'll be meeting with the applicant about all of that.
So I move that we defer ordinance 2014-01-01, ordinance 2014-01-02, and ordinance 2014-01-03 to the December 16th meeting with the condition as stated by a city manager referring to the condition of the site plan, if it changes conditionally, and that it be referred back to planning staff and commission.
I'll second.
Any discussion? All in favor, signify so by saying aye.
Aye.
All opposed? All right.
Okay, thank you. Now for item number 2, public hearing, ordinance 2014-09-03, RZ 14-12, amendment to and readoption of Chapter 27, zoning of the Code of the City of Brookhaven, also known as the zoning ordinance in its entirety and for other purposes. This is a public hearing, and the mayor will have to open it.
Open the public hearing.
No comments.
No comments? All right.
All right, Emily and Ben will be presenting. I think we'll start with Emily first.
All right.
As you know, the City of Brookhaven has a 2-year transition period in its charter to adopt all of the ordinances from DeKalb County, and that ends in December of this year. And we, as you know, also in August of last month, we readopted the official zoning map. We've also gone through and made amendments and readoptions to Chapter 14, and we've also just recently had the consideration of the comprehensive plan, which we submitted to DCA. In light of all of these things that have happened, we need to go back and readopt our zoning ordinance to make sure that we're incorporating these changes into the City of Brookhaven. And so really briefly, I want to discuss some of the changes that we've made from DeKalb County's ordinance in the proposed ordinance that's in the agenda package tonight. The proposed ordinance is staff's recommendation. It's based on staff's analysis of the zoning ordinance, and it also will include as Appendix A that official zoning map that we adopted in August, which is in the back of the room. So going through, the overall changes throughout the ordinance is we removed all references to noise, since now we're regulating noise in our noise ordinance. We don't need noise limitations in our zoning ordinance. We took out all references and definitions applicable to overlays only in DeKalb County that aren't in the incorporated boundaries of the City of Brookhaven. We deleted the environmentally sensitive overlay because that's, once again, not within the boundaries of the City of Brookhaven. We removed references to local laws applicable only to DeKalb. And then we changed all references to the zoning map and to reflect the official zoning map, which is our new title of our zoning map that we adopted last month. We went through and fixed typos, misspellings, and references to sections that were in DeKalb that aren't going to be in the City of Brookhaven. We deleted references to the comprehensive land use maps because our comprehensive plan uses character areas and not comprehensive land use maps. So we went through and made sure that that was clear. And we also took out the amendment process to the comprehensive land map because we won't have that in Brookhaven. The character areas don't have the force of law, so the applicants aren't forced to go through the amendment process. And if we do an amendment, it'll be the formal DCA process. And then we took out any reference to the sign ordinance that are no longer applicable. Really quickly, some very specific changes. In C1 and C2, we added emissions testing to uses that you could apply for special use. We didn't have any emissions testing as an allowable use in Brookhaven before that. In outdoor storage, we removed the zoning district regulation so that now outdoor storage, that provision applies to all districts in Brookhaven. We changed retaining walls. We made it, we clarified that the 4-foot limit is only for single-family detached dwellings. And then we also added a new subsection C, which regulated retaining walls in commercial districts and multifamily. Then we needed to make that distinction between the two different types of uses. Then we went through the application process and the amendment process and cleaned it up, took out some words to make it just a little bit clearer for people to follow. For example, we made sure that the factors in 27.832, that those apply to text amendments and amendments to the map. We went through 27.915 and made clarifications on variances that the ZBA can grant. For example, section E, K, and L, that you cannot get a variance from the second floor in the Peachtree overlay. You cannot get a variance from retaining wall, and you can't get a variance from the minimum lot area. And those were already things that we were using in Brookhaven. We just wanted to make sure that it was clear in that one section. And then we also clarified the timeline hearings for variances in front of the ZBA, the authority to defer, and the max number of days the ZBA could defer a variance. And last but not least, we made it, gave the ZBA authority to hear appeals, variances, and special exceptions from Chapter 21 and Chapter 14. For example, the tree ordinance, the sign ordinance, these are things that already existed in Chapter 14 and Chapter 21. We just made it clear that the ZBA had the authority to hear them in Chapter 27.
Thank you. Ben?
And to quickly recap, based upon the Planning Commission hearing that took place, the commissioners they recommended approval with conditions of the readoption of the zoning ordinance, but they did provide 4 specific conditions. One being related to, I believe it's, just one second.
I've got it, Ben. It's 27.598U7 and 27.775.
Yeah, 27.598, I just wanted to look it up exactly which zoning district it would apply to, and that's to the C2 zoning district, where one of the commissioners found that outdoor advertising services, because there was a clear indication or definition as to what that implied, they felt that it was uncomfortable, or they felt uncomfortable with that provision being a use by right listed under C2, and asked that, or recommended that it be removed. Under Section 27.775, which is under the supplemental regs of the zoning ordinance, specific to, there's a section that refers to signs and outdoor advertising. Again, there were some concerns over the language in outdoor advertising, and asked that heading to strike through those wordings. 27.832, deletion of subsection E, because it was a duplicate of subsection C. 27.832, mind you, is the criteria that is used to review when a rezoning application comes before you. And lastly, 27.844, the commission was requesting that additional thought be put into possibly changing the language associated with successive applications. This is when, if an application was to be denied, the waiting period associated with it, which is typically 24 months. And it was based upon a specific example that we ran into, which was a rezoning, but ultimately was withdrawn without prejudice. There were some concerns over, during that process, there was a breakdown in terms of discussions between the homeowner and the applicant or the property owner that made the application a little bit more difficult to process. And that actually happened after the legal ads went out, after we had the Planning Commission hearing. And because of those concerns, the council, or the commissioners felt that, if an application was found to be defective or unauthorized, that there could be a possibility of reducing the amount of time that they would have to hold back before they could resubmit. But of those 4, staff felt that we could agree with 1 through 3, but felt that condition number 4 would not be required, in that in most instances, staff would not accept an application that did not have the proper authorization of the property owner moving forward. That was a unique situation that the commissioners referenced, but again, the breakdown came about after the fact, after the submittal date, and once staff confirmed that all property owners authorized the approval of the applicant to move forward with the request.
Thank you.
So just to be clear, the 4th condition didn't deal with the 24-month cooling off period. It just deals with property ownership.
Well, it was more related to the fact that they didn't the commissioners did not have a specific time in mind or time frame. It was more of sort of a request to look into, for staff and legal counsel to look into that provision and see if could be any language added to which, if there was an application that was found to be defective or unauthorized, then providing the possibility of reducing the amount of wait time.
And I thought we had some mechanism for being able to reduce the.
That mechanism is
period.
already in place in that after 6 months,
Right.
they could come to the council to request
Okay.
that it be reduced.
Okay.
All right. We need a motion? For number 2?
Mayor, if we could just ask if there are any comments since we've had our,
Did we ask that already? Were there public comments on this?
just to be sure.
No public comments? All right.
It's Susan.
Just making sure you're opening and closing the public hearing.
All right. Closing the public hearing. The motion?
Is it ORD 14?
904.
I move that we adopt ORD 214-09-03-RZ14-112, the amendment to and readoption of Chapter 27 zoning of the Code of the City of Brookhaven, also known as the zoning ordinance, in its entirety and for other purposes.
Is there a second?
I second.
Any discussion?
Yeah, I'd like to amend that motion, make a friendly friendly amendment to add the conditions as stated by the planning department for 1 through 3, if you're willing to accept that.
Is that proper the way that was done?
We have to, I have to have a second on my.
Second on the amendment.
Second on the amendment.
I thought it was included, but I will second that.
All right. And you have to state that you accept the friendly.
I accept the amendment.
Just vote on the amendment now.
All right. Well, we didn't vote on the original.
You have to vote on the
This is
amendment
the original.
first.
Okay. Is there
Amendment.
any discussion on that? All in favor of the amendment signify so by saying aye.
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 All opposed? All right. Now vote on the motion.
Motion.
So the motion has been seconded, right?
No, it hasn't.
Yes, Joe, I thought, had seconded the
did.
motion. Yeah, the original motion.
I did both.
Oh, we did? I'm sorry. I
Yeah.
didn't
All right.
catch that.
Any discussion on that? All in favor of the original motion with the, all in favor of the motion signify so by saying aye.
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 All opposed? All right. Adopted with the amendment.
Item number 3, public hearing ordinance 2014-09-04, RZ 14-0-13, amendment to and readoption of Chapter 21, signs of the Code of the City of Brookhaven. It's in its entirety and for other purposes. And Mayor Davis, you'll need to open the public hearing.
I open the public hearing. No comments? All right.
And Emily will present.
Going along the same lines as the zoning amendment, this is the same thing that we are trying to readopt the sign ordinance so that we can complete our transition period as a result of, as you're aware, the sign moratorium that we placed in order to study this issue and to study the impact of the new official zoning map. Very briefly, we have amended several of the definitions. We've amended the aggregate sign area, the definition of banner and flag, commercial message, and nonconforming sign. And then we've added some new definitions, a definition for LED signs, a definition for monument sign, multi-face sign, tri-vision sign, sidewalk signs, and standard informational signs. We went through and cleaned up the denial phase. We made it clear that if, under our current ordinance, if your permit expired and you hadn't built your sign within 6 months, your permit expired. We gave people the option to come back and get an extension for 6 months if they could show that it was through the fault of the contractor. We went through 21.9 and 21.11, cleaned up some changes, 21.13 just to make it consistent throughout all the changes that we were making. We added in 21-18 ground signs that in the PC districts and in the Peachtree overlay that all monuments, all ground signs had to be monument signs, which was something that was in our zoning ordinance but not our sign ordinance. Another big change, 2121, special event signs. Those are the permits that you get for special events. You could only have them in non-residential areas. We amended it so that churches and schools in residential areas can also have those signs now, too. A huge change was 2122 to electronic signs. We strengthened the regulations on electronic signs. We had not very many in our ordinance carried over from DeKalb County. Now all messages on electronic signs have to be static for at least 6 seconds. It also limits the total area of the sign that you can have an electronic portion of to 25% of the total sign area. We're now regulating the brightness of those electronic signs. There's a different standard for nighttime and daytime. And we're also now requiring annual certification from an electronic engineer to make sure that those signs are still meeting that brightness requirement each year. 21-25 is standard informational signs. This is something that was new at the request of the Mr. Song, and this is 16 square feet or one sign up to 16 square feet or 4 signs up to 16 feet. And the reason we did this was to allow, especially in residential areas or commercial areas, political signs, things like that, real estate signs. We didn't really regulate that in our past ordinance, and this will capture those types of signs, any kind of message that the person wants to have. They just have to make sure that they have the limited area to 16 feet. Sidewalk signs, we brought those over. That was something that was in the overlay that we didn't have in our sign ordinance, so we made sure to put that in there. And then banners. All banners now require a permit, regardless of whether it's in a commercial zone or residential zone, except in the first banner that you get each year is free in a residential zone, that you don't have to pay a permit fee. And then everybody's limited to 3 banners in a year, and they can have that banner up to 14 days. And this was in response to, I believe there was a request for graduation banners, things like that, because we can't make discrimination based on the content of the message. Now we're just limiting the amount of banners you can have to kind of help staff keep an eye on it for traffic and safety concerns.
You're talking about, how big are the banners?
The banners can be up to 24 feet, is that right, Ben?
Up to 24 square feet. Currently, our sign ordinance states 15 square feet.
Okay.
And you still get that 16 square feet standard informational sign. It's kind of one or the other. Your
What's the
total
reason
has
for
to be
a permit?
24. To not have the permit, it's pretty hard for the staff to track how many banners there actually are out there.
Should the staff be tracking how many banners are in people's homes?
If they don't track, well, right now, if we don't track it in commercial areas especially, then you get aesthetic concerns and traffic safety concerns.
I'm talking about for residential.
In residential concerns, I think it's also an aesthetic concern of the neighbors. They can have up to the 16 square feet without a permit.
Right.
And without being tracked.
I just haven't heard an outcry from neighbors about banners in residential neighborhoods, and requiring a permit, I think that's kind of overreaching in my mind.
Well, it's your prerogative to change that part, but it was something that staff requested, just so that they could ensure compliance.
Sure. I think in terms of staff's perspective, in terms of when dealing with banners are more associated with commercial uses than it is residential. It's rare that we do see banners associated with residential, but we can.
Tammy's turning 40, or my son's graduating, and then you got happy birthday, and then that's 3 banners. You got to get a permit for the 4th one in a residential neighborhood?
Well, like I said, technically, what the ordinance states is, with the revision, each parcel, each lot would be entitled to, or could apply for 3 permits for a banner permit.
You have to apply for every time
You have to submit for a
graduation?
permit.
I hope that y'all aren't in favor of that.
With that said, again, it was.
Residential only, so I'm talking about only residential.
Sure. And the thing is this, in terms of the standard informational sign, which is sort of separate from banners, we're treating it somewhat equally across the board, not necessarily making a distinction between residential and commercial, in order to regulate.
Why? What is there a constitutional problem between residential banners and commercial banners, Emily?
You can treat residential districts separately than commercial districts. I think the concern was more about making sure that you're getting that traffic concerns. Obviously, traffic's probably more of a concern in commercial areas.
Well, yeah, if there's something that's blocking view of traffic, I think that's a police issue anyway.
And then in residential areas, I think it's mostly for aesthetic reasons.
I think what you see in residential areas are really the standard information signs, the stick in the mud sign of, Emily's graduating or
New baby was born.
new baby was
right.
born, sort of thing. And those are, you can have as many as you want, right?
Well, you're limited to an aggregate total of 16 square feet.
Right. but-
Without a permit?
But
Without a permit.
Right.
So you
So-
can put those up all day long.
I'm
It's
just talking
the
about the ones you
banners.
get at Party City, or you get, a 5-foot, 6-foot wide banner you hang up.
Well, it's 6
Lordy,
foot.
lordy, Marie's turning 40.
It's by the area, so 24 square feet
I
is
just-
rather
I think
large.
that's
sign.
over. We've never had a permit for residential banners before.
We've always had permits for banners. This is actually.
Residential?
Yes. Yeah, if you're putting one up under the DeKalb code that we've had, you're supposed to have a permit.
Well, I'm against
And that's
it.
why
Yeah, the
we've
thing is-
asked, give us a break on that, especially for my neighborhood puts up graduation banners, a lot of neighborhoods do. If you want to put up your Max is turning 40,
So if I got a kindergarten graduating kindergarten and
buy a 16-foot sign and put it in your front.
I just don't,
Have we had an issue with this from a complaint standpoint?
It, again, is more related to commercial
I'm asking you a
use of
question.
banners.
Have we had a
Residential.
series of complaints that we've had to address on this issue? in
on the
city of Brookhaven?
residential.
Yes, from the commercial-related banner use.
We're talking residential.
Oh, from residential, no, not specifically related to banners, no.
Thank you.
I can tell you, I have had personal experience with residential banners in which neighbors have complained because there was a person who didn't like a development going on around the area and had a huge sign saying greedy developers bleep.
Well, that's obscenity.
No, there was no obscenity. I mean, it's just, I don't want to use the slang that
Oh.
was used in it. But so, I do have an issue with having,
Well, they could still
having
have that
free
banner.
reign.
They could
I mean,
still
I
have
think
that banner, right? Under this.
Well, that's right, under 16,
That
under
doesn't
square
solve that
feet.
issue.
They would be governed by the laws of obscenity, but
Well, this wasn't obscene, just slang.
Is there a time limit of how?
But that one was, is there a time limit?
14 days.
So for banners,
Right.
is a time limit of 14 days. Standard informational signs, there's no time limit.
Yeah, so, I mean, I can defer to having some regulatory ability on residential
All right,
signs rather than
Mr.
not.
Personal Freedom over there.
I am a big believer.
if I could, Your Honor, I did forget to mention 3 comments that we received. There are 2 typos that we need to correct, and then our GMA counsel, Laura Henderson, recommended that we delete the word scrolling from 2122A3, since we've already regulated it, that the electronic sign can only be for 6 seconds.
I just want to go on record as saying that permits for a residential banner, to me, is silly and over-regulation, and I'm opposed to it.
I hear you. I hear you.
Y'all want to be silly, y'all go ahead and vote.
Mayor, did you open the public hearing?
Yes, I did.
Okay.
Rebecca?
I'm just really reading this banner section.
Nannier. It's a nanny.
Actually, the problem in my neighborhood is that there's somebody who's a big Auburn fan who has painted
That's what it's
the
about.
Auburn insignia on his front yard.
That wouldn't even qualify under this.
It doesn't even
That's not even
qualify.
regulated. yeah.
So, people do all sorts of things.
I'll be in favor of banning any Auburn signage. I think that's not a choice, that's not a personal choice.
I think it might be
You
a
know-
content-based discrimination.
Georgia people don't like the Alabama signs, and the Alabamans don't like the South Carolina fan signs, and,
So, J-Max, if you
Yes.
took your residential sign, so
Yes.
what are you proposing?
I don't think you should have there shouldn't be a permit for a residential sign. It should just be,
So there isn't for under 16 feet, so you're saying no matter what the size?
no, there should be a sign limit on how big it can be because of aesthetics and if it's blocking traffic. But to have to require a permit after you have 3 banners in a year is silly to me, and it's over the top.
what about if we just
I can get
say you
behind
can have
that.
unlimited number of banners?
Well, just for clarification.
Say no I just don't
Wait,
I don't like the term permit for
There-
signing in your own yard. I just don't think
There's a
that's.
clarification that needs to be had here.
Well, I think clarification, first off, I want to make a distinction between standard informational sign and banners. In terms of the material, it's very distinct to the separation, so you got to be mindful of that.
Right, we're not talking about standard informational signs, 'cause that's not part of the discussion.
I understand, it was just
Just
brought up
banners.
from Councilman Bates. The other aspect of that is, as well, the permitting aspect, I understand, the mayor, you're not in favor of that.
Because
The reason-
permit means permission.
I
You
understand.
need to get your city's permission to put a sign or a banner in your yard. I think the more I say it, the more angry I get about
Right.
it.
The reason why we suggested or recommended a permit was to regulate for a time limit. Without having a permit in place, it's hard to regulate and to confirm how long
Why?
a banner has been out.
Why?
Again, this is not specific just to residential, mind you. I'm just talking in large of
I'm
the
talking about
banner.
just residential. I understand the commercial completely.
Sure.
I understand the rationale behind that.
But, again, that same issue could come up in terms of a property. It could be a dilapidated property wherein someone puts up a banner and a banner is left up on the property for months and months, sometimes to a year. We have seen that across the city, where we don't necessarily have the enforcement to say, well, remove it, because technically they could remove they could be complying in size, they could be complying in setback, but it was meant to be used as a temporary
We'll just
sign
put a limit.
option.
I mean, you can document how long it's been there without a permit.
I think that's what he's trying to say. It's
But-
hard to document it
Well,
without a permit.
it's hard, but in order to not infringe on people's rights and make them get a permission for a banner, maybe we got to do a little work on something like that. That's not a big problem in Brookhaven. Yeah. That's just what I think. It might be a little harder, but I don't see a big rash of banner problems all over the residences of Brookhaven. Maybe there are here and there. If we got to do a little more work, I'll go take the picture. You sign me up, I'll go document when it's there.
One free
I'm
banner
just
and
trying to think through
up to
this.
4 years, you have to
I
pay
know,
for
for instance, the folks at the Green Market have wanted to have a bigger banner. So if they put the banner, hung it in a residential area, this would apply to it, right? It would put a limit on it, or a time limit, or would require a permit.
Yeah, I mean, again, if we're not treating it as a special event, you are correct in that it would fall under the guidelines of that section related to banners.
No, well, it's a
one, and then the
nonprofit.
next 3 up to 4 year.
It's not residential, right?
Free calendar.
Right, that's my point. Slippery slope.
The issue I've got is, I'm really not opposed to what you're saying. The problem is, I just don't, I think we may have to, the changes needed in this zoning ordinance, I mean, if we can find a way to say this clearly that identifies what you're saying,
Where are you on that?
we're at section 2129 on banners, but I'm just thinking for the sake of time tonight, is there a way to pass this ordinance?
Liberty
bring this
has
thing
no
back
time
up?
limit.
We have gone, this is beating a dead horse.
Well, yeah,
But,
when you want Miles to have a little sign and you want KK to have a sign, and you want to celebrate your, birthday, and then
Hey, if
Stephanie
you can
doesn't,
figure out a way-
if Stephanie doesn't get a banner because you got to get a permit for it.
If you can figure out a way to state these changes,
Yeah,
then
okay.
let's do it. Because,
Is the issue seeking of a permit?
For a residential banner, yes.
Okay, but one of the banners that the resident can obtain requires no permit.
Right.
What do you
correct.
mean, one of the
The
banners?
first one.
The first one, or it
Well-
could be if they choose, I'm going to pay for the first one, but I want the second one free.
Well, that's free.
Well,
Why
because-
why are they asking the city, can I have a free I just,
No, because one, they're allowed 3
right.
per year.
But on that fourth one, you got to go to the permit.
Well, you would for the third one too, but.
Oh, for the third one.
But there's one that is available to you at no charge for the permit.
That sentence, it's what I have a problem with.
Okay.
That we're telling people, I just want to,
Well.
Bates
what-
asked me to see if I can make a quick amendment. Exactly. As
Well,
long as it's not a public safety or obscenity.
If I could,
Or just
Your-
take it out.
I think it's the 5, subsection 5, that you have issue with.
Right.
21,
2129.
2129.
2129, section 5.
Yeah, why don't we just
This-
delete that?
So the only, well, you,
Otherwise, people assume that all banners have to be permitted then. You need to have something that says, addresses residential banners.
Well, that's what it says, each lot from residential zoning. The other ones apply to commercial?
Right.
Well, so if you take out the residential one, you're taking out the residential
Well,
element.
then
It's just-
then
just
I would
applies to
assume I need a
commercial.
permit to put up my graduation banner.
Yeah, the way it's written, that specific provision was put in separated for residential to
Right.
account for that
Right.
one banner that's free.
What about if we just make it 3 banners a year or something?
You could, for example, say for subsection 5, banners in residential zoning districts shall not require a permit.
That's it.
Okay.
Thank you.
well, hold on.
Yeah.
Hold on. Now you've taken out an important element of this, of the time. The 14-day period is important because you don't want those banners to become permanent.
I think you
Right,
could
but
keep
No,
it,
it's 14 days
Right.
if you don't take out a
Exactly,
permit.
and that's what I was just going to suggest, because the part of the permitting, whether there's a charge or not, is to regulate the time period in which the banner remains. So if there is not a start date to that, then when there is a complaint, that becomes an issue because there's no way of counting, unless you count the complaint as day one, or what the mayor suggested, if he rides by and sees it, when you take notice of
Right,
it, that is
exactly.
the date
Yeah,
that it is
right.
identified as being day one. The issue is, there's no enforcement power on the city to remove a banner, especially if there are complaints.
Well, unless-
We
but-
have no
but-
way to
But when you've set the
accommodate.
time limit down. when you
Correct,
know what-
and that's what I'm saying. If you're going to eliminate the
Permit.
charge or the
The permit.
requirement of a permit, but allow for the number of banners to be permissible for each individual residential property, then there still has to be some specificity to how large it can be,
Sure.
what the requirements are to that.
Sure.
And also to state that there is a 14-day period. Now, since you don't have a trigger on when that 14-day period starts, because,
Other than when code enforcement is called and they document when it's there.
or they drive by and they notice it and they
Okay.
take a note of it.
Right.
So
So
we've
all it
got to
does
be
is
sure.
it messes with the 14-day requirement, maybe by another week or two, or whenever somebody complains. So if somebody has to deal with a banner being up a couple of weeks too long, so that we as a city don't adopt an ordinance that says you have to get a permit for your third banner, I'm fine with that.
Okay, I just want to be sure that we have a means to remedy a problem. So
Okay.
I think that if you're going to remove the permit requirement and state that banners are permissible for residential properties, then there has to be, but here are the regulatory requirements. Certain size cannot exceed.
It's there.
And then to state that it cannot be hung for more than 14 days.
That's there.
And then with an asterisk there that says the 14-day period will start the day that the city takes notice of it or a complaint is lodged.
That's the sentence we need to add, that one sentence, because all the other stuff was already there.
Okay.
So we
And-
eliminate the first one and add that sentence.
And one other point, just to remind the mayor and council, remember, we're under a moratorium, so as soon as this ordinance is adopted, our moratorium lifts.
Right.
Okay,
Yeah.
so let's
Now-
get
We've
on
been
that.
in a
Well, now-
moratorium for quite some time.
And if I could,
Yes.
I would ask also if you did amend that section, that you amend 21-9 and include a subsection 10 to say banners in residential areas in accordance with section
Well, you'll read those-
21-29.
You'll read the language and then the motion, if
That
that's what
is
they want to
what,
do.
yes.
Okay.
Now, hold on, before we get ahead of ourselves. The issues that need to be in this are that if you strictly eliminate this section,
No, we're just eliminating the one sentence, so we're leaving the rest of it,
one sentence, which sentence?
one that Emily said to eliminate.
Subsection 5.
Yeah, that's extremely important
No, but I
section.
thought we were leaving the requirements there, but taking off the residential permit portion of it.
That's in
All right.
21-9. 10 would be
That takes
making
care
it
of it?
clear that banners in residential areas don't require a permit.
All right, but you can put these
then
criteria with that
You would
2910.
need to make Marie's amendment in 21-29-5 about the enforcement and the time limits.
All right, let me make a recommendation here, because the important thing is, if you think through, somebody who, if you take all restrictions off on number or size, you can have somebody who's a residential who just says, look, I'm putting a new sign in my yard every, 14 days.
Who's
And
doing
You've got
that?
a permanent, well, I'm just saying.
What problem are we addressing? Who's got this banner
That's
problem?
aesthetics. I mean, I don't think it's a good idea to have residential banner signs in perpetuity on.
I will put up a banner
20
every day saying you're a nanny state. Bates Madison is a nanny state on my.
It's important to have a means of regulating, residential signs, so that you don't have signs in perpetuity if you have a neighbor dispute. So let me propose this. If you were to say each lot in a residential zoning district may display
Banners.
Banners not exceeding 24 square feet without a permit. However, this 14-day period shall count towards the maximum of, what do you want to say, 9? You have 9 children?
I don't want to say any maximum. I just don't think it's a problem. I think we're just.
Well, if
we're
you
doing
don't
it.
have a maximum, then you've got signs of perpetuity, and that's.
Where? I don't know where the problem is. I don't
Well, in my neighborhood, it was a sign that sat there for 2 years, a banner.
And if, with the Marie's amendment, that would be illegal, because once we have notice of it being for more than 14 days, then we can say it's taken down.
It's not another 14 days.
It's not 2 years, it's 28 days.
Yeah, but if it's without a maximum number of signs, that new sign goes back up, and it's 14 days in
Let's get the language
perpetuity.
here so we can get this done. What did you suggest, Marie?
I said that while no permit would be required, didn't we, I think I said 14 days, but the date when noticed by the city would count as day one, or when a complaint was lodged with the city, that would count as day one.
Why don't we do this? Why don't we eliminate the section 5, and then our next meeting, we can come back and amend it with that.
There you go.
We'll get the proper language, and we'll get it, instead of going on about it.
Well, don't we have to go through zoning procedures? Does it have
Yes.
to go back through planning commission and everything?
That
So that's-
amendment does?
Yeah,
Yes.
That's a
any
problem.
amendment to that.
I contend that if this is that big an issue, let's
Well, obviously
leave it as
You gotta
is,
get
and
permits for it. That's why it's a big issue to you.
if we compromise at 9 14-day periods.
If we change it, does it have to
Yeah.
come back through planning again? If we amend this?
You could amend it here.
If you amend it on the record here, it's fine, but if you wait for later, you have to
Okay,
go back
okay,
through the
so, all right.
re-advertisement.
I've exhausted my limit of arguing on signs.
All right. I probably don't get to vote anyway. I'm just telling you what I feel, and that's what I think. Go ahead.
If I could point out the 2 typos, I don't think I actually told you where they were.
You did.
Line 2, it says safe, it should say safe instead of same in the definition of directional sign. And then in page 12, 21-14, it says Comer visibility instead of corner visibility.
Just say corner or instead of comer, or comer instead of corner?
Are we ready to entertain a motion?
Yes. Is there a
All right.
motion?
You have a-
I'm
Trying to fix
All right,
that.
I'm just going to make this up.
I was going
Do you have
to,
one?
I think I've got it. I think I've got it. A
Shoot, I
good
just-
compromise.
Good, because
that-
I just
that-
lost my page. Oh, here we go.
So I'd like to propose that have we closed the public hearing already on this?
No. All right. Close the public hearing. Are there more comments? Okay, all right. Are there any comments, new comments from all this discussion? Sure, or you just give a card.
I've given a card,
Okay.
but not on this.
Okay, all right, we'll just use it for the same.
Just would ask you to look at the flag section. The way I read it, I don't think it's a good idea that the city of Brookhaven limits 2 American flags on a lot, particularly around the 4th of July. I like to put out a lot of little flags.
Oh, yeah,
I think it looks bad that you're more concerned with graduation flags than people showing their patriotism. I think you need to look at that very carefully.
So the ordinance is this
2 flags.
28 flags.
2 flag poles.
And it's flag poles. Would staked flags, would that?
How is
Holiday
pole-
decorations are generally excluded from sign ordinances.
Okay.
What is it? Do we have an exclusion for holiday decorations?
We do not regulate holiday decorations.
Is that what it says?
If it's not in our ordinance, we don't regulate.
Well, it doesn't give an exception, though, if you're,
Silence is the exception.
So So
It says on officially designated city, state, or federal, there's no maximum flag size or number or other limitations on display. Doesn't that cover it?
All flags shall be displayed on the flag.
All flags will
But
be-
it says, but there's, on holidays, there's no maximum flag size or number or other limitations on
What
display.
if it's not a holiday?
I will tell you, this is a pretty model ordinance from the
Yeah, but I've
Georgia
also
Municipal
seen news stories
Association.
about people being told they can't have the flag, and it's, we don't want to ever have that
So if
that
we can,
situation.
We don't have any limitation on what a flagpole is or the size of flagpoles, so.
so if we can add an amendment to specifically talk about excluding holiday signs.
On G,
Yeah.
subsection G does, if you wanted to limit that, to change, that would be the part that you would change. It says, on officially designated city, state, or federal holidays, there shall be no maximum flag size or number, or any other limitations on display, is what it says now.
Did you
Okay.
give a card?
I have not, I'll fill one out.
Okay.
Just as long as public comment is still open, I came into this late, and my apologies for that, but I've expressed to several city staff and several of the council members previously an issue with the Brookhaven Farmers Market and the banners that we have. And we have had $900 of banners since March that we've not been able to display. We finally were told at the end of August that we could put them up. We put them up, and code enforcement came by and gave us 24 hours to take them down. Due to the size, I understand we're now going to 24 square feet, where we would be below that and we would be okay. My concern is the 14-day window. The market runs from March until end of November every year. This year, it's going a little longer until December 13th. But it is a community event run by a nonprofit organization. There is no paid position. It's a volunteer board trying to do something good for the community. And we've invested a lot of money into banners that we've not been able to use at all this year. And as a result, and we have had banners in the past, mind you, as a result, we have had a much lower turnout at the market than we've had in years past. I'd like you guys to consider something, whether it's a special event or, I don't know how you word it, but I'd like to have a consideration for an amendment to the ordinance that would allow something of that sort, a community-sponsored event, to have a banner up longer than the 14 days or 14 days for nine periods in a row or whatever the case may be. Thank you.
That's a good comment. Ben, where
Where's
are
the
we on
special
that?
event?
That's a commercial church parking lot. What would apply?
Corey, do they stay up when they're up?
Oh, it's a residential lot.
It's a church.
It's
and
a
residential.
church, but it's a residential
So
lot?
You're doing it what, for one day every week, right? One day a week? Come back up. The lot is zoned R75.
Okay.
It is technically a commercial use with the church there, but it is zoned R75. The market may or may not be in the same location next year, so, that could change.
Right.
But generally speaking, it would be on a church property, or if the city was willing and the future boards were interested, potentially in a park. The idea in the past, we put the banner up at the start of the season, and it was up throughout the season. And, if you put it up on a Friday night for a Saturday morning market, you're not getting a whole lot of drive-by traffic to see that there's a market on Saturday where you pull it down that next day. We have smaller yard signs that go out around the neighborhood. I'm sure you've seen them, bright neon green this year. Those are left up in residential lots as well. But the main banners at the site of the market that we've had in the past did stay up throughout the season.
How would our current ordinances as written apply to that?
Our current ordinance or the
Or
ordinance
that's proposed here?
that's being proposed?
14 days.
In terms of the proposal, most likely in that situation, it would be considered a special event sign. But then again, we don't regulate the content. That's one thing. So I think it's more to do with the length and the duration of a banner being allowed to be placed on the property. Currently, the way, or we have recommended in terms of a special event sign, what's stated is under subsection 5, this is section 2121. Maximum number of special event sign permits to be issued to a single site or location. shall be limited to 2 per calendar year for a period of not to exceed 16 days for each issuance.
So y'all go a good bit longer than that.
Go a good bit longer
Four-
than that.
4 or 5 months? How long? Is it all,
We're going,
you're going to
this year, I believe
December?
it's like 9 months out of the year.
Yeah.
Corey, have you all thought about getting a permanent sign?
It's not a permanent location.
I don't know that we really can because it's not a permanent location and it's not our location. It's, being held on church property where we're kind of at their discretion as to what we can and can't do. They were okay with banners. The Boys and Girls Club across the road was okay putting 2 banners on their fence. That's where we actually just put it and had to remove both banners 2 days later, so.
Yeah. The one option that's available, I understand that, the farmer's market went and expended, okay.
Suspended.
Well, no. What I'm quite amount of expense was used to, manufacture the banners. One option that is available through this proposal is a standard informational sign. Standard information sign is somewhat functions as what we allow the banners to function now, which is somewhat in perpetuity, although it's intended for temporary uses. We don't regulate the content, and it purely would be based upon the approval from the church. But mind you, you won't get 24 square feet, you'll get one 16-square-foot sign. I don't know if that's a viable option, but that option is available. That's something that could be put up and be left on the property.
Ben, do we have a release valve in any of these, in any part of this ordinance that allows for exceptions or an opportunity for?
Administrative variance?
And an opportunity for people like this to come forth and state their case and put in for an exception?
At this point, the way it's written, no, we do not.
Maybe we want to consider that?
Maybe a possibility, yes.
Emily, do you need to speak to equal protection in that regard?
Yeah, we want to have the permitting requirements pretty consistent because of equal protection and because of the First Amendment. When you have licensing schemes, you have to have articulated standards to make sure that you're not exercising unbridled discretion. And so when you start getting
Why
into
don't we
things like
bridle the
that,
discretion?
that's
we
what we
bridle
would
it?
have to do, and that's what we're attempting to do by putting these permit requirements.
What if you do a administrative variance for certain, put some restrictions on what you can administratively vary?
We do have variance provisions, but they're not really meant for these types of signs. They're more for the permanent structures.
Yeah, as I understand it, the variance for the signs would come before the ZBA.
Yeah, it's in-
Understanding those rules as I do, it would not be
I'm
granted
talking about
variance.
administrative variance, not ZBA variance.
But right now, that's the only place to appeal. You can appeal sign issues to the ZBA.
So if y'all had, what did you call, Ben, that last one, that informational sign?
Standard informational signs?
What section is that?
Well, I think it's important to just review the definition,
That's just in definitions.
and that's also section
2125.
2125, which is packet page 399. And again, just to quickly state for the record, the definition for standard informational sign. A non-illuminated sign with a rigid sign face made for short-term use, containing no reflecting elements, flags, or projections, and which is mounted on a post, stake, or metal frame with a thickness or diameter not greater than 3 1/2 inches. Each standard informational sign shall not be greater than 6 feet above ground level and are limited to either one sign that is 16 square feet in area or up to 4 signs not to exceed an aggregate sign area of 16 square feet. Banners are not included in the definition of a standard informational sign.
So in this case, would this banner somehow be excluded for that, in that last definition, that last statement?
Well, banners, yes, it would be excluded, but it will fall under its own separate
This-
definition.
This would be considered a standard informational sign for the Brookhaven Farmers Market.
It depends on the material of the sign.
Yeah. If we were to hang our banners that we currently have, they are 21 square feet, so we would be above the 16 square feet allowed.
And
We
you-
would only
you
be
want-
allowed one per lot
You need
on a
three?
frontage with, 300 feet of street frontage there on
Yeah.
North Druid,
Yeah.
as well as the frontage going down the side. I mean, it's really,
Well, right now, per the current sign ordinance, you're still limited to 2,
Right.
banners. It doesn't
two's a
necessarily.
whole lot better than one, though.
Well, I understand,
When
but it
we're
doesn't
dealing with
necessarily
that-
regulate the fact that, again, I understand you could put 2 along North Druid Hills, but yes, you're limited to 2. On the flip side, you're limited to a size of 15 square feet.
Yep.
That's the other
Total.
issue, I understand.
Total?
Each banner is
Each
limited
banner.
to 15 square feet.
A 15-square-foot banner, for reference, Bates, is
Yeah, I know.
essentially, you're driving by, you're not going to see it, you're not going to notice
no.
it. That's why
Typically
the city
3 by
took it upon
5
itself
is-
to try to change that.
Right. Yeah.
I think that's a change that's greatly needed. I just don't know that going back down to 16 square feet under informational signs would achieve that same purpose. It doesn't make a whole lot of sense.
Yeah.
You're asking really for an unlimited amount of time to display the banner.
No, not unlimited. I'm asking for, I think there should be something, irregardless of the market, I think there should be something in our ordinance that allows for an administrative variance for something that is for the greater good of the community. It's not a business out there trying to promote itself. It's not somebody sticking a sign in their yard saying, I'm against the redevelopment powers, whatever the case may be.
Well, that
It's
passed-
a community event.
Yeah, it's a great solution. Well, it passed legal muster.
My concern with that, it would be content-based.
Right.
You can technically favor speech over commercial speech, but it is probably not something that I would go down that route. You're subjecting yourself to some potential liability. It all has to be content neutral based on the message.
Emily, do you have a solution?
Oh, an
Can you-
administrative variance?
Can you suggest a solution, Emily?
There are several ways, I guess, you could go about it. You could limit, if you removed the number from residential areas, I think that would, at least right now, as you're located on a residential property, do it. You could change the number of special event banners that are allowed. A third solution would be, instead of 14 daytime periods, is that you get 60 days total throughout the year, or some other number that you picked. That's also another option.
Also, on the flags thing, there's no, since it says all flags shall be displayed on flagpoles, can we make an exception that if it's less than 1 or 2 square feet, then there's no, it doesn't apply? Because you got the little flags that maybe sometimes the flag is bigger than the little stick that it's on. And you got somebody, you see some people putting 5 or 6 of those little ones out, Memorial Day or just in memory of a relative or somebody when they passed away or something that might have been a veteran. I just don't want to limit it to holidays, and I think that saying all flags shall be displayed on flagpoles, you're going to run into a problem with somebody wanting to put little ones out where maybe it's not a pole, or maybe the dimensions of the flag are bigger than the little stick that it's on.
But all of those signs, wouldn't they fall under this holiday sign? But I guess you're talking about just on a day that.
Any old day.
Any old day. I mean, I'd love seeing a street that's lined in American flags.
Yeah, not just on a holiday.
So, can we put that section in? Can we do that?
Do y'all want to do a special call on this next week?
Well,
It's
the
kind of
issue
important.
is.
It's a bigger issue here.
There are a lot of issues here, but the issue is I really want to see us lift this sign moratorium, which is holding up a lot of businesses, and we can't do that until we get a sign
If-
ordinance passed.
If you do want to take a little bit more time, I would encourage you then to extend the moratorium until you meet back, if it's another 10 days or another
Well,
8
look,
days, whatever, next
the-
week.
The flip side is, worst-case scenario is we approve this as stated, and then it takes us 60 days to fix some of these issues that we're dealing with today. Problem is, I know this Brookhaven Farmers Market needs a solution today, and their
But
season's going to be over
But
at the end
Emily
of the year.
just said, if we do away with this unlimited number in residential areas, you're good,
Okay.
right?
I believe
Yeah.
so.
Is that what I
I believe
heard?
so.
Basically, you'd just be able to roll your signs every 14 days. You'd be, you have an unlimited amount of times you can roll on that. Now, I see that as being somewhat problematic if somebody wants to, go to the wrong side of, I can't stand my neighbor's house color, and I'm just going to roll that banner in my yard every 14 days.
I don't disagree with that, Bates, but I don't think we've ever had that issue.
Well, I mean, I can tell you that
Yeah.
a greedy developers suck sign stayed up for 2 years, in my neighborhood. Well,
I stand corrected.
where
I mean, it
it's a,
happens, that's the problem.
it does. Neighbor relations, they get heated. And people are, I wouldn't put it past people to go against their neighbor with a banner. But I would defer to actually find a solution that that addresses what we know is a known problem that we need to find a solution for tonight.
And Mayor, if I could, as to your flag issue, you could amend the definition of flag to put a size limit, that it only refers to flags. It does not apply to flags
The little
below
flags?
a certain size. Ben, how big do you think those flags are?
It's less than a square foot.
Yeah, I would assume at most it would be a 1 by 1 in most scenarios. But I think more than, if you were to regulate the height of a pole or
No.
the base, well, what I was saying is, maybe not the size of the flag itself, but the height of some type of post, mind you, you could regulate it that way, instead of putting a regulation on the size of a sign, or a flag, because mind you, if we say it on the record right now, we added into the definition that a sign larger than 1 square feet would require, or that
Flag.
it comply, or sorry, a flag that comply with the requirements of the section related to flags, that's going to be problematic as well. You may have to say a flag that's placed on a post that exceeds a certain height. That may be the better solution, and it may be, a foot in height, 2 feet in height, because that would also regulate for the size of a sign that could be attached to that size of a post, so.
Can I make a
That's an option.
suggestion? We'll just amend section 21-28A, and if this is council's desire, subsection A, all flags, and then insert a paragraph greater than blank feet shall be displayed on flagpoles. So you create a minimum on the flagpole.
Great.
Anything underneath that minimum, you would not have to be on the
All right, what's
flagpole.
the
Greater
minimum?
than what,
Greater than
3 feet?
Well, there's
Three.
3 by 5 or 3 by 4?
Oh, no.
You're
Yeah,
talking about the pole height.
Well,
Yeah,
yeah,
if-
pole height, greater than 3, I think 3 feet.
If you're talking about pole height, then maybe, 3 feet at most, but if
Talking
you're.
about flag size.
But Tim's talking about the actual flag size and placing a minimum, stating if you were to go over that threshold, then you would have to comply with the section related to flags.
All flags,
More than 2 square feet?
Yeah, all flags.
all
more than-
flags greater than blank
Greater than
square
2, yeah.
feet shall be displayed.
On flagpoles?
It's
Yes.
21-28.
Yeah, and 2 square feet may be appropriate, being that it would be a 2 by 1 typically, so.
Right, that's the
All right.
little ones and the medium size, and then the next size up is the 3 by 5.
I think I'd like to entertain a motion, make a
Eliminate
motion.
the residential, and we got to do the flag thing,
I think so
right?
I may miss some things, and
Yes.
staff correct me.
Need to close public comment.
Oh, yeah.
We got to figure out what we're going to do before we, any more comments, by the way? All right. Close the public hearing.
So, do you need a motion to have a discussion about
You
it?
capture, we're doing the flag and the
Banners.
taking out the banners, the residential.
Yeah.
I'm not sure I have 100% clear direction on the residential.
Well,
what you
Tim,
want.
I'll
Tim's
tell-
guy, let's do Tim.
I'll tell you
does.
what I have,
I'm messing
because I've got it, Tim.
Yeah.
I've got yours, and I think I've got the residential flags. Also, we've got some spelling errors that I'm just going to say, you pointed those out.
There was 2 spelling errors, and then Laurel Henderson recommended that we remove the word scrolling from 21-22A3.
Yeah.
Corner,
And then corner instead of comer, and then safe instead of same in the definition of directional sign.
all right.
So,
I don't trust Bates to do this one because he's going to try to sneak through the regulation.
I would like to make a motion that we adopt ordinance 2014-09-04, RZ 14-13, amendment to and readoption of Chapter 21 signs of the Code of the City of Brookhaven in its entirety and for other purposes with the following changes. Section 21, 25,
29.
no, sorry.
Flags was 21-28, if that's what you want.
The
Section
residential,
2128, subsection A, all flags greater than 2 square feet
needs
shall
to
be
be,
displayed on flag poles, and then continues.
that's the language you want to insert. Right,
That's
Your insertion would be greater than 2 square feet.
right.
correct,
All right.
correct. Also, section
2129.
2129 banners,
5,
section 5, state
strike.
each, no, we need to keep it. But
Need to say they're allowed.
each lot in a residential zoning district may display banners not exceeding 24 square feet without a permit. However, this 14-day period shall count. Actually, I think that section I struck.
Shall begin on the date when noticed by the city.
Yeah, shall begin on the date when noticed by the city. And there's no mention of maximum. Also, make the additions of the two spelling errors as stated by our city attorney.
And the word change.
So,
Corner versus Comer?
corner versus Comer.
Comba.
Do I need to reference the section that is?
That's 21-14B.
In 21-14B.
And then the other one was in the definition of directional sign, the word safe instead of same.
Make that change as
And
read by the
the
city attorney.
third was to delete the word scrolling from 21-22A3.
Make that change as stated by the city attorney.
Mr. Madison, you mentioned that the 14-day period shall commence on the notice of the city. We had also talked about, or if a complaint was filed, because we could not notice something and only notice it when
How does
it's.
that protect farmers market?
Yeah, I'll amend my motion to, as stated by the city attorney regarding that, section 2129, subsection 5, as stated by the city manager.
Not the attorney.
And then, as a correlation with that 21-910, you would need to say that banners in residential areas in accordance with 21-29, showing that they were exempt from permit requirements.
And amend my motion as stated by the city attorney on this side.
All right, is there a second?
I'll second.
Any discussion? All right, let's reopen this discussion here. Keep going.
I think we got it.
All in favor of adopting the ordinance as amended several times, signify so by saying aye.
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 Amen.
Opposed? All opposed? All right. Next.
Okay, item number 4, public hearing ordinance 2014-07.
Wait, did we close the public hearing?
You did.
Okay.
Yeah.
Ordinance 2014-07-05, RZ 14-10, Ashton, Atlanta Residential LLC, rezoning request from R100 to RA8 to construct a 22-unit, single-family attached development for the property located at 2972, 2978, 2984, 2990, 2996, 3002 Hermance Drive. This is a public hearing. Mr. Mike Busher, who is Vice President with Ashton Woods, is the applicant. However, we did receive notice this evening that it is their intent to seek a withdrawal without prejudice. He is here this evening.
Good evening. My name is Mike Busher, and I work with Ashton Atlanta Residential. So as Marie said, we'd like to withdraw the case. I'm happy to answer questions as to why, but principally, that's what I came here tonight to, it was to request. And without prejudice would be the owner's request and ours as well.
We'll open the public hearing. There's a public hearing, right? Okay.
You know, I guess I'll address it in the form of a question, but I know that you've had ongoing communication with the neighborhoods and tried to work with city staff to find a resolution for this development, and I want to commend you for the hard work that you did based on the instructions that we had at our last meeting. I think you've done a fantastic job and shown yourselves to be a quality developer with the right intent to have good outreach into the community. But, I think that for the benefit of the public, I don't know if it's proper, if you feel comfortable, but, letting us know as a city, what went wrong on it or what we could do to, help bring good developments like this in the future.
Sure. No, I appreciate the kind words. This is really a case of, in reacting to the feedback on the site plan, it ultimately changed the orientation of the buildings. And if you can kind of visualize the property in your mind, we had sort of two problems. One was the city stream buffer, 75-foot buffer that we knew we were going to encroach into probably two of the units. And then the other was just the grade change is such that our original plan ran perpendicular to the road and enabled us to kind of save on some of that dirt balance. But when we ultimately had to switch the units and run them parallel to the road, you would ultimately have to bring that site up considerably. So that cost alone was enough to be problematic. So I don't know that it's necessarily a catch-all that you could take away from it. It's a difficult piece of property. The sellers really, for their part, tried the best they could to bridge a financial gap, but then it becomes just at some point where we have to respect what they want to get, and ultimately, we have to kind of be where we are. So that's really what ended it. And kind of abruptly, even as of today, we were trying to figure out was there any way we could solve it, but we just couldn't.
Well, thank you for trying.
Yeah, well, hopefully, who knows, maybe it can be resurrected, I don't know, but we'll certainly keep trying in other places, so.
Thank you.
Yeah.
I just want to reiterate what Bates said, is I really loved the new plan and kind of thought it came up with an even better plan than what you had before, but, the site plan doesn't necessarily show the topo and the other problems as well, but I really appreciate it. You went back to the drawing board and you did exactly what we asked you to do, and I'm just sorry that, I was surprised to see your letter that things had fallen apart, so
Yeah.
don't give up on us, keep
No, I
coming
won't.
back. We welcome you all in the city.
Yeah, well, likewise. Well, I'm sure we'll find other things to work on.
Thank you.
Thank you.
Any public comment?
Yes, Alan Coates.
Hi, my name is Alan Coates, 2978 Hermance Drive. I'm one of the 6 property owners. Before I say anything else, thank you for resurfacing Hermance Drive.
Thank you.
Thank you. Thank you. Second thing, I want to thank Ashton Woods. They've been wonderful to work with. I'm really sorry that this hasn't worked out. I hope I get the chance to work with them again. I'd be proud to. Third thing, and the last thing, one of the most problematic things about this was something that I thought was a ditch in my backyard turned into a stream. I'm going to work diligently to get that reversed. There are 4 storm drains on Hermance and nearby streets that cut off of it that are the head of that so-called stream. 12 hours after a 4-inch rain this month, there was no more flow. It's a dry bed probably 350 days out of the year. So if we can get that turned around, that would be a major obstacle that would allow more to be done with that property. Thank you.
Thank you. All right, is there any more?
Mary Ellen Layden.
Mayor Ellen?
Mary Ellen Layden, 2942 Crosswick Forest Drive. I'd like to continue the Love Fest. The last time you saw me, I was very opposed to this development. Ashton Woods went back and worked and worked. They have put a lot of time and money into trying to comply with this. I came back before the Planning Commission 2 weeks ago and surprised them all by saying, I'm now in favor of it. I'm sorry it hasn't worked out for them. And again, like you, I want to thank them. They have a great deal of integrity, and I'd like to see them continue to build here. Thank you.
Thank you. Anybody else?
None.
Okay. Anything else? All right, we'll close the public hearing. No action needed?
You do need to accept their letter of withdrawal
Okay,
without
without
prejudice.
prejudice, okay. Is there a motion?
I move that we accept the letter of withdrawal.
Without prejudice?
Without prejudice, as stated by the applicant.
Is there a second?
I'll second.
Any discussion? All in favor of accepting the withdrawal, signify so by saying aye.
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 All opposed? All right. Next.
The next item, ordinance 2014-09-05, RZ 14-11, Haven Real Estate Investments Incorporated, rezoning request from R75 to RA8 to subdivide 2 lots into 4 lots for development of single-family detached dwellings for property located at 2319 and 2323 Briarwood Hills Drive. This is a public hearing, and Ben will present.
As previously stated, the rezoning is from R75 to RA8 to subdivide 2 single-family lots into 4 single-family lots for construction of 4 single-family detached residential uses. They're requesting a density of 7.2 units per acre, which in comparison to the established densities of the existing homes out in the area, it's on the high end, as currently the density ranges from 3.37 upwards to 6.75. In addition to that, the request that was made, staff felt that the extension of the RA8 was too far from the existing RA8s, which are typically found along residential nodes, fronting along actual roads itself. This request is for 2 interior lots along Briarwood that back up to Kusawati. There were also concerns that were brought up by the public in regards to the right-of-way associated with Kusawati and then the ramifications that may come out of it, specifically related to on-street parking. Based upon those concerns and the items stipulated in the report, staff did recommend denial. Planning Commission also supported staff recommendation and recommended denial of the request as well. Thank you.
All right. Any questions? All right. Any comments? Is there a public hearing on this one?
Yes, there is.
I'll open the public hearing.
Andrew Bracken.
The applicant
The
speak first?
applicant is here.
Applicant. I'm
Yeah,
sorry.
yeah,
Oh, the applicant,
first.
I'm sorry. Go ahead.
Yeah.
Sorry, Mr. Bracken, and sorry, applicant.
Thank you all for your time this evening. Excited to see everyone again. We appreciate y'all taking the time to review this for us. We did have a wonderful Planning Commission meeting just a few weeks ago, and the staff and the Planning Commission all recommended conditions. We heard the voice of the public, we heard the voice of the commission. I did want to save a good bit of my time for rebuttal, but I did want to address some of the specific concerns that were brought to our attention. I've got 4 main points. My first point being that we are not looking to request spot zoning. I have a map of Kusawati Drive here, and I'll be honest, I thought my projector thing was going to be here, so.
it still not-
You can get it working if you,
Well, it's okay, I can pass this along to y'all. Basically, what I'm showing is, if you're coming up Kusawati,
Is it the same as that?
yeah.
Public can see.
Here, you put it on the,
Or you can put it on the table.
I think the other one's easier to read, though.
oh, yeah, focus in.
Probably hard to read, anywho.
Just pull it towards you a little bit, towards you. There you go, and then go down on it there, Susan.
Okay, so what this is showing is basically the continuity of RA8 coming all along Kusawati Drive. If you look, Kusawati Drive,
Keep going.
coming this way from Dresden, up here, all is RA8. Where it hits Telford.
There you go.
You again have 2 RA8 properties.
There we go.
And then when you cross Telford, you have 2 existing R8 properties that were recently developed, which have 2 existing R8 properties right next to them. Then you come to where we are in our request.
You
to
have
where
to
you
back
have-
out now.
To where you have 2 properties that are not RA8 yet. So we've got 2 open-ended. One of the applicants is in line next month to do the same rezoning. The other applicant is unfortunately just had an untimely death in the family, and they're not ready to address this at this time. So we show RA8 all the way up across Telford to this point. Okay? And then these are the 2 properties that are adjacent that we're discussing that are not. Again, this property right here has their application in to do the exact same thing. This property has the intent to do it, however, due to the tragedy with the mother, they're not ready to do anything yet. So we have been hired as representative of the applicant. We're working for the homeowners here. We have no interest as a builder in these properties other than helping out our clients. The property right here, This lady is actually working towards her retirement. She's a long-term Brookhaven resident, has been here 40, 50 years, has been in this house this entire time. She is really looking to maximize the highest and best use of her land, which is her right as a citizen in the city of Brookhaven. As far as the conditions go, at the time of the Planning Commission meeting, I hadn't had a chance to review all the conditions that they had requested. However, since then, I've been able to get with my surveyor and get with my developers, and we're able to meet every condition except for 7 and 8. The only reason that 7 and 8 were not conforming at this point in time is because they're requesting us to have a 25-foot right-of-way from the center line of the street, which equals the 50-foot right-of-way. There is an existing 40-foot right-of-way, which equals 20-foot right-of-way from the center line of the street. That's already there and in place.
Say that one more time. I don't mean to take up your time, but that was a lot of numbers there that were important.
So, one of the main conditions that they proposed was us having 50 feet of right-of-way, which means 25 feet from the center line of the street. The existing right-of-way, as in its current use, is 40 feet, which allows 20 feet from the center line of the creek. The condition proposed by the planning department to have us do 5 extra feet then makes us not conform for the lot requirement to rezone. If you were to impose that additional 5 feet on us, you would also cause an offset in the existing right-of-way, which would cause a weird jut out, which doesn't, in my opinion, doesn't make as much sense. So the only condition that we're looking at that cannot be addressed would be to maintain the existing right-of-way as it currently is. Now, when looking at these properties, I know that the Planning Commission talked about, the reasonable economic use of the land, but the Planning Commission did not speak to the highest and best use of the land, which again is the citizens' right to be able to do as they see fit for the highest and best use of their land, which takes me back to our longtime Brookhaven resident who has been here, and she's trying to make her retirement, move to Florida. So the other main spot of contention was the traffic. And if we break it down in a nutshell, we're talking about adding 4 extra cars to Kusawati Drive. I'm sure every one of you has driven up Kusawati Drive plenty of times, and you're dodging cars regardless. So the on-street parking is a concern for LJ and Kusawati well before there was any discussion of development on Briarwood Hills Drive. We don't think that adding 4 extra cars is really going to impact it that much. I feel like, based on the studies that the police department did, nobody specified that they had any issue with that. I believe one of the issues stems from maybe the construction parking. Yes, construction vehicles are big, and yes, construction vehicles can be a bit of a hindrance. We're happy to accommodate however the council and the staff sees fit for that. If that means that we only have our contractors park on the construction entrance and any overflow parking is put onto Briarwood Hills, which is in fact wider than Kusawati, we're okay with that. But I don't feel that traffic of the 4 extra cars is going to impact the flow of Kusawati negatively in any way. Those are my main conditions, and I'm going to save it for rebuttal. Y'all let me know if you have questions. And I do have a letter of support from another homeowner and 2 more on the way.
Thank you.
Okay.
Is that letter of support from one of the properties adjacent to either of these 2?
Did you submit for the record?
Pass it to the clerk.
Andrew Bracken.
Andrew Bracken.
I basically just want to reiterate a lot of things that what Allison said. I live on Briarwood Hills, and I support it. I don't believe that it's going to have any appreciable increase in traffic. I think it's a property owner's right, and I think it'll further enhance the development of the neighborhood.
Thank you. Mr. Bracken, next.
Brandon Woods.
Brandon Woods at 1846 Bragg Street. Kind of a long-term residence with Brookhaven, lived in Ashford Park for many years. Before that, lived in Drew Valley. And, definitely supporting the development because, maybe one day we want to move out of our house, potentially build a lot, kind of on that side. So we're here for the long run, and we're looking for opportunity, and we like what's going on in the area, especially what Allison was saying about the Kusawati and the RA8's already developed a couple doors down, so it almost makes sense. So, yeah, in support.
Thank you.
Thank you.
Next.
No others.
Nobody against?
No.
We have comments from email from anybody opposed to this?
No, sir.
I'd like to ask the staff a few more questions. So if you look at this property, in reading through your background of the recommendations, it appears that one issue you have is density. So is that density, if you've got RA8 next to these properties just on the other side, are those conforming in density, or are you comparing it more to the R75 on the rest of Kusawati?
Well, technically speaking, based upon the fact that the character area for the character area states that it's suburban. Suburban allows up to 8 dwelling units, but our review was based upon the existing density of the area. The RA8 to the north, right at the intersection of Telford, Briarwood, and Kusawati, that is larger in terms of the total acreage compared to the property that's brought before you. With that said, their current density is at 6.75 dwelling units per acre. It's still lower than what's being proposed, which is 7.2.
But if R75 is how many units per acre? Do you know
R75, there isn't a specified density. It's
But
based upon the lot size.
Oh, so you really can't even ballpark it?
Yes.
It's just speaking to,
But yes, as stated and stipulated to the report and stated during the presentation, the density that's existing there ranges
Okay.
from 3.37 up to 6.75.
right. Now, speaking about the right-of-way issues that was brought up by the applicant, because apparently they're okay with all the conditions, even though you still recommend a denial on the
Except
application.
for the last two conditions, she said they weren't.
7 and 8 were the conditions, and let me make sure those are the right conditions that we've got.
Right, yeah,
So it's had to deal with, 7 and 8 on my document are both dealing with right-of-way. And one is right-of-way on the Briarwood Hills Drive side, and the other is right-of-way on the Kusawati Drive side. So
Right.
talk to me a little bit more about those.
I will defer to Richard Meehan, the Public
Okay.
Works Director, on that.
Yeah.
One of the things with our local roads, DeKalb had permitted a lot of roads with 40-foot right-of-ways in the past, and we're trying to get, as we redevelop these roads to get up to the standard 50-foot right-of-way. Yes, it would cause, in response to what the applicant said, it would cause a jog on this, but like she also stated, the adjacent properties are also coming in, and, we don't know what's going to happen further on, but the idea is that, we would ask for this condition on all the properties to try to build that right-of-way. When on Kusawati Drive itself, on the opposite side of the road, the right-of-way now is actually technically, I think it's 45 feet, because when the other side of Kusawati redeveloped, they did dedicate the additional 5 feet of right-of-way to the 25-foot from center line in Kusawati as well. And a lot of that's just to have room, future sidewalks or utilities in there, because when you have a 40-foot right-of-way, there's not a whole lot of room for us to get in there and do anything behind the curb line.
Right. So, having passed this street many times, I recognize, particularly on the Kusawati Drive, how often it is used by the fire department. Fire department vehicles, what's their width, do you know? Off the top,
They'll tell you they need 16 feet wide, but I don't think they're that's for a rural vehicle.
Yes.
I think they're more like 10 feet or so, 10 or 12.
Right. So, it is increasingly a cut-through street between Briarwood Road and Dresden Drive. I know that this application has been heard by our planning staff and recommended for denial, heard by our planning commission and recommended for denial. And I would advise the applicant, if they're willing to take a look at taking a second look at this rezoning application, I think it would be a smart decision to try and figure out other solutions which address the concerns of the planning department and planning commission. And if the applicant were willing to entertain a full cycle deferral to be able to do that, I think that would be a smart move by the applicant. But certainly that decision is completely your decision. But I agree with the concerns of our planning department and the planning commission. And I think that while love to see the houses that Haven builds, and I know that y'all do a tremendous job and are quality builder, we have as a city, we have a duty to make sure that we address the density and traffic conditions on Kusawati Drive, particularly as an emergency road cut through and as a cut through for traffic. And I think that the right-of-way issue on that, particularly on the Kusawati Drive side, I just don't see as a valid solution in the plan as it's proposed. So,
If I may add to council, I mean, just to address the one question that you had, Councilman Bates, in regards to density, although R75 doesn't have a specific density, if we were just to compare the lot size, that's another factor that was brought up. Typically, R75 in that area, it ranges from 9,000 upwards to 16,000 in terms of the largest size that you'll find along Briarwood and Telford. This request, in most instances, is going to meet exactly the needed requirement in lot size for RA8, which is the minimum of 6,000 square feet. In addition to that, the other aspect that we didn't necessarily state in the staff report that it's spot zoning. We're not mentioning that. But what we're saying, it is segmented from the existing RA8 and the existing patterns of development that has occurred over the years in that area associated with the rezoning from R75 to RA8. Again, it's closer towards the actual transitional node. It extends from the transitional node in towards the neighborhood. Not necessarily does it start inwards and expand outwards. And then we are considering the two lots that are brought before you as interior lots within that existing development.
yeah, I mean, I would love to find a solution for areas like this, because that strip of land in between Kusawati Drive and Briarwood Hills Drive, you've got some houses that, the RA8s next to Telford Drive have driveways facing Kusawati Drive. They look great, but they certainly are, right up on the road. But then you continue up towards Briarwood on Kusawati Drive, and you're faced with, overgrown hedges because it's behind somebody's fence that faces out on Briarwood Hills Drive. And that's unsightly. We've got curb issues there, but increasingly, in the city's planning, we have a need to create a pedestrian-friendly area. And so, right-of-way issues on Kusawati Drive so that we can have sidewalks continue probably on both sides of the road eventually to connect these commercial nodes to Dresden Drive and Buford Highway. And our parks will be really important. So the right-of-way issues are problematic here. I would contend particularly on the Kusawati Drive side. In the area on Kusawati Drive, most of those lots that you see in the strip between Briarwood Hills Drive and Kusawati Drive face the Briarwood Hills Drive. I think that you've got one or two rear entries to some lots from Kusawati Drive, and then I think at the ends, you've got, houses with
All right.
driveways on.
Any more
Kusawati.
comments? All right, we'll close the public hearing.
Bates, if you were suggesting they go back through a full cycle, what would they come back with?
Well, I'm not sure. I think that if you could solve the issues on the Coosawattee Drive right-of-way side, that's the main concern in this rezoning. Because if you can't address that increasing of density
Right-of-way.
there, the right-of-way there, and you bring a house that's going to be RA8 where it's 5 or 6 feet off of the curb, and that trend continues for the rest of the way down Coosawattee Drive to connect to the green houses that are RA8 on Telford. You're going to have it's going to add to those right-of-way traffic problems that are already existing. But if it somehow were shifted to the Briarwood Hills Drive side, and it could work that way, I can completely understand the applicant's concern about, if you just make these two lots jut in 5 feet, how are you creating a solution by just those two lots? I don't really think you are. But I simply know that developing those houses and adding for potential on-street parking on Coosawattee Drive is going to be very problematic. That's a design issue that I would say if the applicant can figure out a way to address parking issues on Coosawattee Drive, or maybe make use of Briarwood Hills in the development of the two lots better. I don't know. I mean, I'm not sure that there is a valid solution, but
We did 3 houses instead of 4.
potentially,
2 on Briarwood, 1 on Coosawattee.
potentially.
Well, I'm bothered that it does look like spot zoning to me. I'm bothered that it's completely surrounded by R75. And then there's just this little tiny green at the top, which I assume we inherited from DeKalb. Now, if it is the will of those residents for that A8 to come all the way down, then maybe that will happen. But I'm bothered that you're a little island out there. Were you saying that the 2 lots between you and the existing A8 are potentially going to be in play in the near future?
Yeah, I think.
I wonder if it wouldn't make more sense to include the larger site, because again, you're sort of this island, and I'm telling you, if I was one of those R75 people, I'd be upset with you
Sure.
changing
And-
your zoning like
And
that.
that was, the city staff, they let us know that we needed to come in all together.
Yeah.
And like I said, I'm working for homeowners here, and I
Right.
didn't necessarily have all of them on board.
Right.
So the one right behind me is literally a month behind me, and the other one could be a month, could be a couple months.
Sure.
But they
You
plan
have
on.
no control over that.
Right, no control,
I
but
get
that is the intent. And I think the other thing is too, you did inherit, and believe it or not, Haven inherited this rezone. We didn't rezone that. We built it. You inherited this, which therefore caused this kind of ugly thumb in the middle of there. Our intention was if we continued it down with the intention of the neighborhood, then we would have some continuity, because this property is the last one that meets the minimum lot square footage for this rezoning. So with the intent of
Well,
that,
it
we
stops
knew.
with yours?
Do what?
Stops with yours?
Yes, sir. Yes, sir.
Because
So-
they narrow?
Yeah,
or
because
what?
the street narrows.
Yes,
I can
it
see that,
narrows.
yeah,
So
okay.
and the thing is, we have all of the adjacent property owners on Telford and Briarwood Hills, they're all in support of us. They all
Yes.
came to the public participation plan, they all wanted to submit letters, they're all in support of this because they are looking to increase the value of their properties, and because there are other rezoning applications in for this exact area in different spots.
And there was no opposition. I asked Ben, did you receive any opposition emails or letters?
No, sir, we did not.
Right, I already asked that.
So, I don't know if there's any more questions.
Yeah. You're going to recommend
So
deferral?
let me just make sure, so the A8 that exists, the 50-foot right-of-way is not in effect for them. Richard, it's 40 feet up at the A8. So you'd still, even if they came to that, what is it, 2337, you'd have a jog-in on the street, right?
Right.
Yes.
And if we are instructed to do the 25 feet, well, then it makes us not conform for the lot rezoning. It has us come up shy on the square footage required.
Yeah.
Richard, what is the benefit of requesting this type of 25-foot off center versus 20 if the neighboring properties are at 20?
With the redevelopment, I mean, it gives us, like I said, it gives us the room to have for doing any widening or any widening of the road or any sidewalk addition in the future. I mean, one of the concerns with that road, like we've said, it's the right-of-way width is narrow, but also the roadway width is narrow. The road only measures about, Kusawati only measures about 18 foot wide at that point, which is pretty narrow.
The entire length?
The entire width of the road is measuring only, it's tough off of GIS, but it's only averaging about 18 or it's between 17 and 19 feet at that point.
And the fire truck needed 16?
Is 12, but with that, I mean, you don't really, you basically park one car on the side of the road and it would violate our parking ordinance of leaving 10-foot free space. So you'd have to sign it, no parking on the road.
Right.
So did y'all have a proposed sidewalk in the site plan, or
So
was there room for
that's
that?
part of it. You know, when we're coming in and doing this, we're putting new sidewalks in there for
Yeah.
you. We're putting new granite curbs in there. So we're doing things that, I'll be honest, I'm not sure what the city's time frame is on it. And we all know that Kusawati is becoming a major traffic road, and it's actually quite dangerous as it exists. So there has been sections of sidewalk done, but we're coming in paying for sidewalks to be done for you and make it more of that pedestrian-friendly, walkable area that you're looking for.
Yeah.
And as far as the construction parking, everything goes, I'm happy to say no on-street parking. But are we going to turn around and tell all of Kusawati and LJ Drive no on-street parking?
That's right.
I mean,
That's the
if
problem.
you drive down there, you're dodging traffic all day long. I've been out there in the middle of the construction, and I've watched my fire trucks go by without problem. I've watched my dump trucks go by without problem. So I respectfully see what everybody's saying, but I don't think it's any more of a hindrance than what currently exists right there.
Well, construction blockage is a temporary thing, and it's excuse me, it's a byproduct of redevelopment. But Richard, if indeed the other homes are at a 20-foot setback, these two being requested 25, the only two remaining that can go 25 are the two north.
Correct.
All right, so your whole net gain out of that is 4 lots, because the lots narrow at that point thereafter, and they're not going to be able to be zoned R8, they're going to stay their current. So what's the net gain? I mean, you're going to have a truck could be able to come down and then,
Well, the right-of-way width, I mean, that would allow us in the future, if we ever had to come in and widen Kusawati up to a standard 22 to 24-foot width, it would just mean that's right-of-way we wouldn't have to acquire, because we would have to acquire the right-of-way, possibly have to acquire right-of-way width from all those other lots on Kusawati. But it would just mean that we wouldn't have to acquire it from these lots that were redeveloped.
so given up as north to the east on Kusawati, that's a 25-foot setback from center line?
Across the street from these two properties and the two properties to the north, it already is 25 foot from center line,
Okay,
according
so
to our GIS.
If you did a sidewalk, wouldn't it make more sense to do it on that side of the road if you could only do one side?
I believe there is a sidewalk already on the other side of the road.
How wide is it?
It's
It's
off the
wide.
top of my head, it's maybe 4,
How
it's
wide
at least
was
4
yours?
feet. It's at least 4. It's not a 3-foot, but I can't say that it's 5, but it's at least 4.
All right. Is there a motion?
Yeah, well, all I can ask before we make a motion is that the applicant consider whether or not they would request a full cycle deferral or a withdrawal of the application
Without prejudice?
without prejudice.
Sure, it's a loaded question. We're not necessarily ready to give up on this. I feel like this is something that's good for the city of Brookhaven. It follows the city of Brookhaven's motto of development and bringing in additional tax revenue and new growing residents and everything the city of Brookhaven speaks to. So I don't think we want to withdraw. I would respectfully request a defer back and let us maybe regroup and see if we can come up with something that makes more sense for the planning department and the commission.
Correct, we don't have a motto, we don't have a motto yet.
I'm making your motto for you.
But, you know, part of the motto then needs to be that we protect existing neighborhoods. And so
Yes,
we
ma'am.
just always have to be cognizant of all those people surrounding you that are at our R75.
Absolutely.
And the character designation for this is consistent, and this is not a creep down, it's a inner center and under the encroachment type of perception here, so.
Yes.
All right, is there a motion?
Yeah, so I'd like to make a motion that we accept the applicant's request for a full cycle deferral. Do we need to put dates on that?
Yes, that would be,
Would you have to
full
close the
cycle back
public,
to
was there a
you
public
all?
hearing on this?
To
I have to close the public hearing.
Yes, thank
Yeah.
you.
Sorry, so I make a motion.
October 14th.
First to Planning Commission,
Oh, you wanted to go back to the planning commission?
PC, yeah, full cycle.
Okay, so is that October the?
They'd be able to make application in October?
Actually,
In November?
I think November would be preferable on our end.
I think the reality is that it would require, this is going to require time to work with the staff, and I think that if there is the potential for redevelopment, possibly coming in with all 4 parcels might make more sense to find a way to accommodate some of the space issues.
Do you agree?
So the motion is to accept the applicant's request for a full cycle deferral to be heard on by Planning Commission on November
November 5th.
5th.
And if I may add, Councilman Bates, a provision requiring a revised site plan to be submitted by a certain date, and that preferred date would be October 13th.
To have a site plan submitted to our planning department by October 13th, or revised site plan by October 13th, and then ultimately to be heard by city council on November
The 18th, because we're off days for November and December.
18th.
Your second?
I second.
Any discussion? All in favor of the deferral, signify so by saying aye.
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 All opposed? All right, the item's deferred.
Thank you very much.
Thank you.
All right, next.
Okay, that concludes our public hearing. Yes, our public hearing items. We have nothing under old business. Under new business, item number 1, consideration and approval of authorization for the city manager and the mayor to enter into a contract with Terramark Land Surveying Incorporated for stormwater system inventory and inspection survey. This is part of our stormwater plan and MS4. The cost of the and funds for the contract are $58,290. Recommend approval.
All right, is there a motion?
Go here on, I'm trying to find the number for it. New business, consider.
It's just a contract authorization.
I'll move that we approve, the authorization for city manager and mayor to enter into a contract with Terramark Land Surveying, Inc. for stormwater system inventory inspection survey.
Your second?
Seconded.
Any discussion? All in favor of item 1's motion, signify so by saying aye.
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 All opposed? All right.
Item number 2 is ordinance 2014-09-01, consideration and discussion of ordinance amending Chapter 18 nuisances apartment inspections. We discussed this at our work session 2 weeks ago, and this concerns the allowance and the ability for the city to audit interior inspections that are required pursuant to license renewal for our apartment complexes. I have heard from Penny Round, who is representing the Apartment Association, and she is in agreement with these changes.
Is there a motion?
I recommend we approve
Hold
ordinance.
on. We got to do a public comment on this one. What it says. Yes, we need is there any public comment on this?
Aubrey Valines?
He's on the next one.
Okay.
All right. Any more public comment on this ordinance 214-0901? All right.
I move that we approve ordinance 2014-09-01, consideration and discussion of an ordinance amending Chapter 18 nuisances apartment inspections.
I second.
Any discussion? All in favor of adopting the ordinance signify so by saying aye.
Aye.
All opposed? All right.
Thank you.
Number three.
Number three, consider ordinance 2014-09-02, consideration and discussion of Chapter 4, alcoholic beverage ordinances, pouring hours survey has been included of the alcohol pouring licenses, and review of, and contact with the establishments, along with discussion of SLUPs. And we presented this at your work session. Myself and Chief Yanduris were available to answer any questions if you have them.
Public comment. Do you have any questions yet? I guess we've beaten this one with a dead horse, so if there's any public comment, we can do that now.
Aubrey Villines.
And I have one to read in the record.
Okay.
Which one do you have for the record?
Aubrey Valines, 2900 Chambly Tucker Road. I'll be brief. We would ask that you just consider whatever changes you make in the hours, that you realize that we're competitive with the city of Atlanta and Chambly and the cities surrounding us, not just within Brookhaven ourselves. We compete with all the other clubs that are outside of Brookhaven. I know that Chambly recently raised its time that it's open. I was looking at your summary of input that you put in there, and we would welcome the opportunity to pay an increased amount to stay open later. And that's all I would say. Look at the fact that we just don't compete within the city of Brookhaven. We compete all over the metropolitan area. Thank you.
Any more?
Justin Pate.
Justin Pate, 2715 Buford Highway, Rush Lounge. Couple questions. Why are you guys going to be doing this when you are not a full council? Is this not an important enough issue to you that we would wait until the fourth member who represents other citizens is part of it? Two, at our last meeting that we all had, that we were all together on, the issue was noise. You guys passed a very, very stringent noise ordinance, and from what the police officers who work at my location have told me, it's been very successful. I thought we had an agreement at that point that if noise was no longer the issue, that we could leave this issue alone. And it seems that's not going to happen. I know several of you ran on the idea of transparency in government. How is what you're doing transparent when I hear more about what goes on with this council from the Brookhaven Post than I do from any of you, and you all have our email addresses, and you've reached out to us before, but you didn't like what we had to say. So that's not transparent in the slightest. And I find it very interesting that you'll spend well over an hour talking about banners, yet when it comes to people's livelihoods, you seem to act very cavalier with it. And why is the late night ordinance part that was originally in your work session packet no longer seems to be a part of this? Thank you.
Anybody else?
None.
Okay. You want to read one of the record? Okay.
The first one is from Todd Lantier, of the chairman of the Brookhaven Chamber of Commerce. And he says, first, I'd like to say that I respect and appreciate the work Mark Koeman did on the survey. I believe it points out the division of opinion on this topic and can be debated pro and con. On one hand, there is the argument for free commerce and that the few establishments that serve a niche clientele should continue to operate in the same fashion as they did before the establishment of the city. However, if, as Chief Yondor points out, the later pouring hours are becoming an issue of public safety, and by reducing the times alcohol is to be served is in the best interest and safety of our community as a whole, then the safety and welfare of our citizens is paramount. As I have mentioned before, I believe there is room for compromise on this issue, and I would like to make the following proposal for consideration. In line with Mayor Davis's original proposal for compromise he made back in May, pouring and closing times be level and that we adopt the Saturday and Sunday times of 2:55 last call, completed consumption by 3:25, and vacating the premises by 3:55 a.m. I would support a late-night pouring permit be considered as a way to regulate and monitor these establishments that choose to stay open later. I would also propose that any changes made to the ordinance go into effect sometime next year, 1st of June, for example. This would allow those whose businesses who are most impacted by the change to have an opportunity to review their business model to increase efficiencies for profitability, compliance, and safety. And he thanks Mr. Gebbia for his service and the council to the community and for allowing an opportunity to be heard.
Thank you. Is there another
Then I
one?
have another one from Joe, William Hines. And he is talking about this ordinance, and he supports a 2:00 a.m. closing time for all bars in the city of Brookhaven. And he has attached a lot of information for you to read, and he's asked that I read another statement for him, which is about 2 paragraphs. Do you want me to read it?
So William Hines, right?
Sir?
William Hines?
Yes, William Hines Jr. Mayor and council, I speak today asking that our elected officials carefully consider all information, studies, and data provided by our police department and private citizens while taking actions and voting on this ordinance. Please let the action you take be fair to all. Please take into consideration that your action tonight could save a life or lives. Please understand the fireman's rule. My understanding of the fireman's rule. The fireman's rule does not allow our first responders to sue for a negligent act that causes them harm or death while on the job. Any city ordinance that willfully puts our first responders at more risk of harm is irresponsible and reckless. Will your vote tonight put our first responders in a preventable, risky, bad situation that will cause them harm? Excuse me. Please understand that safety for all should always trump profit and greed. It is safety for all is not first, and you have put a price of worth on a human life. So what is the price for your family member or best friend? To the point, put a dollar value on your own child or wife or husband, and please share with us what is that price. And he says he's provided the mayor, council, and staff with a lot of documents, and there's a lot, including like MAD statistics, fact sheets, and it goes on and on with documentation.
All right. Yeah, I think we got his email too. Thank you. Any more public comment?
If people are interested in that, that will be posted as part of the record,
Right.
correct?
Okay.
Okay. Is there a motion?
Do we have comment time up here?
We have to have a motion on the floor.
Motion, then we'll have discussion.
I move that we change the closing hours to be at 2:30 last call with a 3 o'clock close.
Is there a second?
I second that.
Any discussion?
I'm just going to reiterate that this is actually later than the city of Atlanta, which is at 2 o'clock, as presented in our very lengthy discussion in both last session and just a few hours ago. Dunwoody closes at 2, Roswell at 2, Sandy Springs at 2. So I think this is well in conformity with the surrounding municipalities. I would ask the chief if he wants to reiterate any of the crime stats that you've been collecting and have shared with us that go on between 2 a.m. and 6 a.m. The one I find most staggering is the DUIs of some 66 DUIs during that time.
Yes, I don't have the complete statistics with me, but as I mentioned before, and I mentioned the statistics a number of times, what I was worried about mainly right now is our violent crime is escalating. The earlier part of the month, we had a jeweler that was shot in the parking lot at closing time of the Icon Lounge on Buford Highway. We made an arrest on that, and he actually made a statement to the officer when we went to Grady Hospital to interview him, saying that we're becoming known as the frequent partygoers as the late night spot in the Atlanta area. So we're getting a lot of traffic for that reason.
And while you had recommended 2 a.m. closing, 2 a.m. last call, 2:30 all out, we're putting it a half an hour later. Are you okay with that?
Yes,
It's better than what you have now, right? It actually is not all that different from the Saturday closing, right, which is a 3 a.m., 2 255? Okay.
You know, my comments on this are that, you know, I believe that, I believe we need to be aware and understand the chief's public safety concerns. You know, I'm very open to this dialogue and a change of the hours because of that reason, that we've got a corridor of commercial activity that has a lot of calls for service at these late night closing hours that are potentially going to make it difficult for our Brookhaven police to respond in our residential areas within a 3-minute period. The two things that I would like to see the city do is to take steps that are not as drastic a change as what we're proposing. I would be supportive of a close time at 3 p.m., out the door by 3:30.
3 a.m.
Sorry, 3 a.m., out the door by 3:30. I think that's a more moderate first step. I also know that we've discussed the issue about when this ordinance would go into effect, and I believe that a June 1 of next year effective date would allow our businesses to transition their business plans. If they've relied on this business model for years, even predating the city of Brookhaven, I think it's important that we respect that. So, you know, I would like to entertain, if you're willing to entertain a friendly amendment to your motion to change that to 3 p.m., or sorry, 3 a.m., 3:30 a.m. out the door.
If I may interrupt, we have several ordinances, or actually several code sections that contain specific closing times as the type of license you have. So when you make a decision upon what time you want to close it, we'll have to amend each one of those ordinances. We're probably going to have to amend 3. There's an option, I believe you have, that has a late night pouring license option and an option without. So once we go through this, we'll have to adopt an ordinance with whatever time you decide.
So our without the late night pouring, it's 12:30, is that correct? Or what are the hours without the late night pouring?
For us here,
license?
it's 3:55 Monday through Friday with a 4:55 exit.
That's, well, I'm saying without the late night. That's the late
It's
night.
12:30.
It's 12:30.
We just need to eliminate that.
Right.
Okay,
We just talked about removing that.
Before we do a friendly amendment, I'm going to make some comments because there may be more, if you don't mind. All right?
Sure. That's fine.
Are you done?
Yeah.
Okay. Okay. Rebecca already pointed out, and there were some comments made tonight about competitiveness in the region. Just to reiterate, for clarity, Brookhaven currently, Monday through Friday, and when I say 3:55, I'm going to round it off. I'm going to say 4:35, take 5 minutes off because that's the official time. But we're at 4 a.m. on last call, 4:30, drinks done, 5 out the door. Saturday and Sunday, it's 3:30, 4. Right now, as it exists, Atlanta, including the Buckhead area, Dunwoody, Sandy Springs, Roswell, all have a 2 o'clock with a 2:30 out the door. And the only one different from us in the region is Chamblee. They have a 3 a.m. cutoff with a 3:30 out the door. So the chief was originally looking for a 2 a.m. with a 2:30 out, and the recommendation by Councilwoman Williams was a 2:30 a.m. out, 2:30 a.m. close with a 3 o'clock out the door. There are 6 issues that come into play and came up in our work session, and I'll review them very, very quickly. The first and the most important is life and safety issues as put forth by the chief, and that has to be preeminent concern of how we handle the decision on doing this. For him and his force. The second concern that we need to take into account is the impact on the current business and the potential need for them to maybe consider a change in business model and the impact it has on their employees and also their families. And we've had these conversations many times before, and we need to make sure that we're taking them in consideration, which is why the suggestion of looking at a June 1 implementation date or July 1 implementation date. That's ample time for this new regulation to set in and for those businesses to make adjustments to handle. I'm trying to make sure that we do this as a complete package, not just look at hours. So part of the considerations we're looking to do is to secure consistent close times 7 days a week instead of looking at different times Monday through Friday and then Saturday, Sundays. And that's for enforcement purposes, mostly on the part of our law enforcement and make their jobs somewhat easier. The fourth is to simplify our current SLUP program as much as possible. And the objective on this is to secure an even playing field for all businesses, potentially dropping zoning requirements in lieu of noise ordinances, as we discussed during work session. The fifth is to be timely in our decision prior to any alcohol renewal license requirements that we're now putting upon our establishments. So we're burdened with having to make a decision one way or the other now, so that as people come up in the month of November and December, or up in November, and then finally pay for them by the end of December, they know what the ground rules are. And the last point that I'm going to ask, and I've already asked the chief and the city manager to participate in, is to establish a late-night pouring permit to regulate and monitor those establishments that want to move to have an opportunity of staying open later than what the suggested closing hours are this evening. And I put the request to the chief primarily to establish security requirements and what has to constitute the priorities in that permit, because the most important issue that we're actually addressing as we address this issue here is life and safety issues for not only residents of Brookhaven, but for those driving through the city of Brookhaven. So with that, the only other friendly amendment I'd like you to add is an extension date, setting of the initiation date of this for July 1, 2015.
Just as a point of clarity, so our first ordinance that we're going to be considering is just on the regular alcohol hours of what currently state it's 12:30, Monday, 7 days a week.
Tim, you're going to have to walk us through this.
So, yeah, because we've got that ordinance, and then we've got our late night
But you just say
permit.
that the motion could be that these close times supersede and replace all other close times and permits in our code section.
So any alcohol license would automatically allow them to go till at the current
Whatever the
motion,
hours,
2:30, 2:30 and 3 out the door. Okay. And then, but the SLUP is not going to be addressed in this ordinance
No.
change, is it?
The chief and I will come back.
Right.
The ordinance that we presented had obviously some blanks, because we
Right.
hadn't decided upon a closing time. It's my understanding that it's from 9 to 3:55, actually, as it currently stands. Currently.
Right.
Just a couple of days a week.
Let me just,
And we're,
That is true.
and it would, based on the times that you hear, from being presented here, you'll be able to plug those numbers in
Yeah,
directly
I
to this
plugged them
ordinance.
here. I've also, I know there was some, the way the ordinances currently read is there's a period of time you have to stop consuming, and then a period of time you have to leave after last consumption. As I hear
Right.
council's desire is to kind of get rid of that distinction and
Right.
have a stop
30
serving
minutes.
and out the door. So as the way I read it in our ordinance, you can make that, you can
Nobody can
accomplish
see
real
that.
simply right here. So we can read these in, as I've stated here, if that's the intention of council, or you want to have a superseding motion to amend. And there's numerous sections, so we may need to do it like that for clarification.
why don't we just say, remove, it supersedes all contradictory sections instead of having to read them all out?
Well, we've got, the first section is just hours of sale and operation through Monday through Sunday and different hours. And then it has Sunday sales section, and then a late night pouring license section, each one of those having a different blank for hours. And so I think the ordinance
Should just need to say that
does need to strike some
all
of those.
sections that contain language concerning the pouring of alcohol shall be superseded by this ordinance. Be repealed and superseded by this ordinance.
Yeah,
Hold
they're
on.
even repeated multiple times in different
Well, just you
sections.
repeal them all by
And if I could, the reason they're repeated is they're based on different licensing
Right.
establishments. That's the way your ordinance is set up. So one is for distilled spirits, one is for beer and wine, just to change it consistently throughout.
All right, while y'all are thinking about that, Chief, I had a question for you. A last call, last serving time, say whether it's 2:30 or 3, whenever it is, are you concerned at all about getting people out the door 30 minutes after that? Or say the last serve time was 2:30, would, say, 45 minutes later be safer than having people leave 30 minutes later? Like if you say last call at 2:30, people have to leave by 3:15, do you feel like there's a problem rushing people out the door within 30 minutes after they've been served their last drink, or does it matter?
No, because I think if the owners are responsible in serving the people, and the people are responsible in leaving the establishment in order and their drinks, that should be taken care of.
And just one last comment, if I may, Your Honor. On Saturday, the latest it can be is 2:55 per the referendum that we passed for Sunday sales.
That our Saturday time would have to be.
Which referendum was that? you're
The
referring to?
referendum to allow for alcohol sales on
Statewide
Sunday
referendum.
and the state law.
This is so state, the state law is 2:55 is maximum, just on Sunday. On Saturday night.
Which is Sunday morning.
Right. So do we need to go through the procedures of the
So what do
friendly
you want us to
amendments?
do?
or
Can we make one superseding?
Well, you'd have to withdraw, you've already, there's been a motion made and seconded, and then there was a friendly amendment offered. I mean, you probably should withdraw all the motions and start over,
That would be best. Do that.
or vote down the motions and start over.
Can I just withdraw?
Can't you withdraw?
Well,
Or just
you got a
vote?
second on the floor, so that's
So he's
become,
gotta
it becomes a body's motion, so take a motion to withdraw, take a vote of all
All
council.
right, Motion to withdraw. You need to do a motion.
Okay, I make a motion to withdraw my motion.
Seconded?
Any discussion? All in favor of withdrawing the motion, signify so by saying aye.
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 All opposed? All right, the motion is withdrawn.
For further clarification, the section you will be amending is 4-126, 4-128, 4-147, 4-149, 4-162, 4-164. So you got 6 separate sections.
All right, so the motion, the next motion needs to reference what the city attorney's sections that he read off that need to be amended. You can just use his language, but I don't think you have to, unless you want to just have it all written
Give us
down.
his piece of paper.
So first of all, we got to, we're still in sort of the discussion mode. Is there agreement on a time?
Well,
You had said 3, you had said 2:30. I don't know what Joe was.
The reason that I would request that we consider a 3 p.m.
3 a.m.
Sorry.
Say PM again, I'm going to punch you.
3 a.m. last call, 3:30 a.m. out the door, is because it is far easier for us to revisit this issue and say, look, it didn't solve the public safety issues. We need to bring this up and reevaluate it. Whereas if we switch back to 2:30, it is nearly impossible to lengthen that alcohol serving time back up to 3. I believe that it is a step to addressing the public safety concerns. It was, in our feedback from the business community, the survey, it was the most recommended option by the business community. And I also feel that it is a deference to our business community to allow them to know that the city is serious about addressing these public safety concerns, and allow them the chance to be more proactive in addressing these concerns themselves and helping the city deliver solutions, which may not be a ordinance amendment to
Let me ask this.
further restrictions.
With the point that Emily brought up about the Saturday night, in order to have consistency, would you say 2:55 for every night? Because it's what it is on Saturday, and then 3:30 out the door.
Yeah, I think that makes sense. I mean, that provides the standard, that's standard for every night of the week, and that
Chief,
certainly.
Chief, do you have a comment on that?
Well, I still stand by my 2 o'clock, but it's your call. 2:30 we could probably live with.
We keep going, I'm going to go to 2 o'clock. I'm going to make a motion again.
Okay.
I have one more comment in good discussion, and I'll let you make your motion. But what that means is, and we are 1 hour ahead or beyond the closing time of just about every major neighbor we have except Chamblee, then we're equal to Chamblee, with a 3 o'clock close and is that a 3 o'clock close and a 3:30 out the door?
That's not what I'm
No.
doing.
No, okay. I'm just saying, what the conversation is here, that's the summation of the conversation so far. And what I was trying to structure in my response to you originally was a compromise, because I knew the thrust was for a 2 o'clock, which I thought, in consideration of all those considerations beyond life and safety, which is number one, trying to appease that, that was a compromise. But I'll yield to you now and see what you have to say.
I move that we change our closing hours across the board to 2:30, last call, 2:55, out the door, 7 days a week, to go into effect June 1st, to affect sections 4-126, 4-128, 4-147, 4-149, 4-162, and 4-164.
Just,
Is there a second? Is there no second? Hearing no second, the motion fails. I have a question for you. Was the 2:55, was the last pour time, or everybody had to be out time? Or is the last time you can pour alcohol is 2:55 on a Saturday night?
Last pour,
Last pour, so it's not the time you have to be out.
which is
So it
why
could
your
be 3.
It has to be 2:55 last pour, which is what your current ordinance is. That's
Right,
why it was so
right,
much shorter on Saturdays.
2:55 last pour out by 3:30, or I think was what, you were saying 3:30 Bates. I was telling you, if you wanted to do it consistent, you would have to do 2:55.
Right,
And
right,
then-
3:30. And so I make a motion that we approve ordinance 2014-09-02 with a last serve time at 2:55 and out the door at 3:30.
Is that 7 days,
AM.
7 days a week?
7 days a week, and referring to those sections 4-126, 4-128, 4-147, 4-149, 4-160, and 4-164.
Technical question for the lawyer?
With the active date of this ordinance to be enacted by June 1st of 2015, to allow businesses to transition.
I don't need to ask my question now. My second.
Is there, okay, any discussion?
I just think we're going against the chief's recommendation. I thought we were in agreement that public safety was paramount. We're now, going an hour and a half past what the chief recommended. I don't think this does a thing. I think we just leave it wide open, and I think we can just wait for the crimes to happen and the DUIs and, well, never mind. I just don't think we're solving the problem one bit.
Believe me, I take this issue seriously, and Rebecca, I'd love to be able to find a compromise. I do think that we are rolling back the hours considerably on those hours that we are open, that we're currently open until 3:55?
Right, 4
3:55?
4 a.m.
For 4 days of the week.
4:55 was during the week that people had to leave by
Yeah,
4:55 is what it
So
was.
we rolled it back 25 minutes.
Right, but the,
It would be, just to make sure my math is right.
On Saturday night, you're rolling it back 25 minutes.
but my point is this, that this is a first step. And certainly if we don't see a solution that works with our public safety, I welcome you, Chief, to bring this back up at a future date so that we can readdress this. Hopefully, we'll continue to monitor the public safety issues. And if this turns out that this is not an effective solution, let us know. And because that is very important. to me and I believe all of us up here, so.
Well, the problem is that you're going to continue to have your police monitoring all the drivers and the crime that's going on around the clubs and not patrolling the rest of the 12 square miles of Brookhaven and doing the proactive policing that I thought we wanted our police to do. It's what the police is, the chief has recommended, and I'm just sorry to see that we're not taking his advice.
I'm just for discussion, because we're in the discussion phase right now. Presently, Monday through Friday, we have a last pour at 3:55.
Weekdays.
What, Monday through Friday is what I said, so it's presently at 3:55. People out the door by 4:55. And so that was a problem that I thought was pretty serious, that you had people leaving bars at the time. Some people were going to work during the week. So Bates's stance is that he wants to do this incrementally, which I think is probably a good idea. If we are rolling back hours, if this motion passes, from a 4:55 people out the door to 3:30. So you're about an hour and a half sooner during 5 of the 7 days of the week. And on Saturday and Sunday, our close times were
2:55.
2:55, so it's the same. We're keeping Saturday, this motion keeps the Saturday and Sunday times the same.
Except the out the door went from 3:55 to 3:30.
And so we rolled back the out-the-door time 25 minutes early, yeah,
Half hour.
for Saturday and Sunday. But for Friday, it is 3:30. Right. All right, just want to make sure people understood what the motion is and what we're voting on. So any more discussion on this? All right, all in favor of the motion, signify so by saying aye.
Aye.
All opposed?
Nay.
So that was two ayes. So in order for it to pass, I would have to vote. So I'll vote aye, and the motion passes.
Mothers, don't let your children be driving out on Brookhaven streets late at night.
I agree.
Next question, or next item.
That concludes our new business, and we're on to other business. And if the mayor would allow me, I'd like to just give a little bit of an update regarding some contracts and budgeting to report to you all.
Okay.
All right. As we move into preparing, as you all know, for the 2015 budget, I wanted to talk with you for a minute about where we are, particularly with contractors and vendors that we have for the city. As you know, we have a number of our departments served by contractors for which we are engaged in contracts with them for levels of service, for the number of staff, for the job descriptions, and so forth. What I'm working on right now is to continue to look for ways to remedy, as I've shared with you in the past, the overhead costs that are inclusive of these private vendor contracts that we have with the city. And so I will be reporting to you and working with you over the next 4 weeks in particular as I start sitting down with you individually and as a group to discuss and review each department budget. Not only will I be doing that, but I'm also going to be reviewing with you particular positions that I would deem as permanent positions that are necessary to serve and provide the operations for the city, and to make a distinction to you all as to what is considered permanent to the overall good of the organization for the operations to carry them out, and then what is really best served by contractors, particularly in your model where you want the flexibility to be able to move up and down with the needs of the city. So I'll be going over that with you as well. Each department is preparing their budgets now. I'm meeting with them over the next 2 weeks to review what they are anticipating in their needs to deliver services pursuant to your requirements. And we'll look at that, and I will review that very closely as to, again, what will be vendor-oriented, and also looking out into the future as to what kind of bids we're going to be looking at for specific services in the future, especially for 2015. we require our contractors, there's a number of stipulations with them, and I want to cite one particular contract that we went through, and it was part and parcel of, obtaining operations of the parks, of the 3 swimming pools in the city, some of which had been closed down and not operational for quite some time, and certainly not maintained properly for citizens to use and to enjoy. So when we took over the operations of these parks that have the pools beginning last Labor Day a year ago, we were moving very quickly to determine what the status and the conditions of those pools were, the pool houses, the bath houses, everything that went along with it, so that we could ready ourselves to be able to operate and provide that level of service to the community. What we found out was what we feared, and that was we had, unfortunately, I'm thinking, and I don't know the full circumstances on the county level, but I would say maybe perhaps due to budget constraints, proper and consistent maintenance had not been conducted on these pools. And what we found were broken pipes, irregular operations of the bathrooms themselves and the showers and the splash pads, and a baby pool not meeting ADA requirements. So we had a whole host of issues. On top of that, we needed an operator. And as you know, we did bid that out, as we do a lot of our operations for the city, and we bid that out to USA Pools. And like all of our contractors, we require them to do background checks. And we talked about that a lot as we were readying ourselves to take over the pools. That we would even require, and our Parks and Recreation Director is working on background check requirements for volunteers. You know, when people are around our children and families, we want to be sure that they're not only in a safe environment for our public safety that serves us, but also those that might be volunteering and providing all sorts of instruction and recreational services. So part of when we do yield and contract with a vendor to provide and perform certain services, we require that they do background checks. And we require a whole host of things, E-Verify, a number of things. And if you'll recall, USA Pools was the vendor that was selected. There was a presentation made by that vendor. It was a competitive bid. And we were very hopeful and excited that we felt we had an experienced vendor. And I'm pointing this out to you just to point out the importance of how we look at all of our vendors and how we continue to require the standards that we do in all of our contracts. What we found, unfortunately, was that, again, part of it was opening up facilities that had long been neglected for whatever the reason. But we found that not only were we observing inconsistencies and lack of performance, so were our citizens, who pointed out a number of things to us which we were very appreciative of. That led us to look further and deeper into the commitment that the city made with this operator. And what we learned very quickly was that simple things such as the background checks were not conducted, which was a contractual requirement. We were made to believe that they had been, and we discovered that they were not. We then ourselves conducted our own background checks with the employees that were serving under USA Pools, and found that we had less than desirable people serving our citizens, one of which had an outstanding warrant. We immediately notified our police department. The chief was notified immediately, and when that person reported to duty, they were arrested. And I bring this to your attention again to talk about how we expect performance levels to be not only maintained, but I expect them, as your city manager, to be exceeded. Because they're coming on board, whether it's short-term or long-term, to deliver services that you deem proper and necessary for your citizens and the level of services that they expect. So while we were very concerned about this, we were able to remedy the deficiencies very quickly. But all that, again, going to say is that, we do have standards. We expect our vendors and contractors to abide by them, whether it's a short-term contract or a long-term contract, and whether that contract is flexible to meet the day-to-day demands of the city or the variation of the demands of the city, whether that be seasonal or for some other specific purpose. So performance is a high expectation of the city, and I know it is of the elected, whether they are employees or they are contractors. So I bring this to your attention to ready you to allow me in the next few weeks to come back to you and talk with you about where it's necessary that a contracting unit makes sense, and where the combination of employees and contractors makes sense, or where perhaps standalone employees make sense. And that will be driven by the permanency of the delivery of that service related to that position, and then what the cost effectiveness is. We've been I'm very pleased and we're very fortunate that in the negotiations of our previous contracts, we were able to save millions of dollars. Much of that came from unnecessary services that the city was not ready for, and what I would deem as extreme overhead costs. So we were able to lower those. So I will continue to work on that, and I will be reporting to you on that over the next few weeks, because I'll remind you again, we are in budget season, and the expectation is over the next 3 weeks especially, and the next 4, we will be finishing up. I'll be meeting with you, as I am with department heads, on our preparation and delivery of the 2015 budget later this calendar year. Thank you.
So we're going to be rebidding our pool contract
We are going to be rebidding the pool contracts. I will be meeting very soon with all of our existing contractors, working with them on what they currently have and making a determination if we need to rebid services.
And I got to commend you on your great HR department in the city of Brookhaven. Rick Stone is fantastic. And I'm
Yes.
sure with great help and advice and from his team, his one-man team,
He's a
that you're going to
one-man
have
man.
a fantastic presentation on.
Thank you.
And sort of off topic, can we get the updates to our parks plan that we passed loaded on the website?
Yes.
Okay, I don't think they're out there
You're
yet.
talking about the park plan itself, the master plan, or are you talking about some of the expenditures that we're still using?
The parks plan that we adopted, but with 7 amendments.
Yes.
Those amendments haven't been reflected on the online version.
Correct, and because we're still working with the consultant to be sure that they've captured every one of those amendments. But yes, we
All
are
right.
working towards
They've
that.
had 2 weeks. We need to capture them.
Yes, sir.
Anything else?
No.
Okay, public comments? Any public comments for, anybody have anything? All right. Mayor's comments? No mayor's comments. Executive session? We don't need executive session. Is there a motion for adjournment?
I move that we adjourn.
Is there a second?
I'll second.
Any discussion? All in favor of adjournment signify so by saying aye.
Aye.
All opposed? We're adjourned.